today we'll be holding a hearing session on the subject of planning and energy policy. And then tomorrow we'll be going on to an inquiry session on the topic of radar mitigation. Can I first ask the parties taking part today to introduce themselves and just check their technology is working, please? First of all, who's appearing for the applicant today?
Good morning, sir. Colin is from Shepherd Wedderburn, appearing on behalf of the applicant. I am joined today by David Bell of David Bell Planning, and also Paul Dunborough from ITP Energised, and he's a technical director EIA, in case any matters arise that we need him to address. So those are the three speakers for today, and we'll interchange according to the appropriate part of the agenda. Thank you.
Thank you. Is that Paul Dunborough, did you say?
Correct. Yes, Paul Dunborough.
Thank you. And for South Ayrshire Council.
So good morning, I'm John Campbell, I'm the Queen's Counsel, and I'm appearing today for the Council on their instructions with Mr. Alan Edgar, a supervisory planner in the employment of the Council, who I think you can see on your screen.
I can, thank you.
And we will do likewise. We will do likewise and respond, both of us, to the appropriate parts of your agenda.
Thank you.
Sir.
And for Bardley Chatton, Knockdolian Estates.
Good morning, sir. Ian Kelly, planning consultant, appearing for the two estates. It'll just be myself this morning and this afternoon. I do not envisage saying too much this morning. I think it really matters for the planning authority, but I will contribute if you wish, sir. Thank you.
Okay, thank you. And Dr. Gordon from Mountaineering Scotland, are you there?
You're on mute, Dave.
Sorry.
It had to happen eventually. Yes, I'm David Gordon, appearing for Mountaineering Scotland. I anticipate having very little to say in the morning or the afternoon sessions. I think most of what we would want to say is already within our hearing statement.
Dr. Gordon, when having said that, and perhaps Mr. Kelly too, I mean, the way I normally would operate these sessions is to go around each party asking if they have something to say, but from what you said, it's better for me just to see if you put your hand up and then bring you in.
I was going to suggest, sir, that I would turn my video off, and if I turn it on, then I'm wishing to actively participate. Would that make sense?
It would, yes, but if I do, by all means, jump in if I don't spot you.
I shall be within the virtual room, as it were.
Yes. Yes. Okay. And yeah, Mr. Kelly, similarly, especially this morning, I perhaps won't ask you on each individual point to contribute, but if you do want to, then make yourself known, and I will bring you in.
Sir, I'm happy with that approach. Thank you.
Good. It just makes things a bit less clunky. Now, for the Mr. and Mrs. Shaw group, I don't think we've got any of those people with us just now by the look of things. Is that correct? So we're expecting Ms. McDade to join us this afternoon. And as I indicated earlier, she I think in the same way as Mr. Kelly, has got most interest in the energy policy aspects. So the suggestion was that we deal with those this afternoon. Good. So as usual, can I ask you please to mute yourselves when not speaking, and for those who aren't actively participating in the hearing, to turn your videos off. I made various announcements at the start of the inquiry regarding such matters as the webcasting of proceedings, COVID restrictions, and the inquiry timetable and process, and I won't repeat those again. But these can all be viewed on the webcast for the 24th of May, available on the DPEA webcasting site. Now, I circulated an agenda for today's hearing a few weeks ago. Can I check that everybody has a copy of that? Yeah. Yeah. I included various questions of my own under the various agenda items, and I will give parties an opportunity to address those. You'll also be able to make your own points. And And inevitably, I've identified some additional questions of my own that have arisen since I circulated the agenda, so I can surprise you with those. I will introduce each item by asking each party in turn to address the question, usually starting with the applicant, unless it makes sense to start with somebody else. And then we'll have a general discussion. But as I say, if you please indicate if you want to speak by raising your hand, and only speak when I've asked you to do so. As I indicated in an email in response to a query from Mr. Campbell the other day, I'm not expecting extensive legal arguments today. So if any such points are required at all, then they may be set out in closing submission. Are there any other procedural points anyone wants to make at this stage? Or should we dive into the agenda? Okay then, well, if I could turn to item 8 then. Just align my various screens. So item 8, National Planning Policy. And the first bullet there we have is about NPF 3. I don't know if we need to say a lot about this. I mean, some things that struck me is clearly NPF 3 is on the road to being replaced. And some elements of it are somewhat dated, particularly the targets, the quoted targets being the 2020. I suppose I'm interested in parties' views for how we should look at those sections that talk about the targets, particularly because I think that NPF 3 is now essentially silent on targets, or is there some way in which I can substitute the a new or different targets into those sections of NPF 3? So perhaps that's a question to get us started with. And Mr. Bell, I see you've come up. So is this? Can I begin with you, please?
Yes.
That point in particular, and then any other particular points you want to make about NPF 3.
Thank you. Good morning, sir.
Good morning.
Yes, I think on NPF 3 we can probably keep it fairly brief. I think you're right in terms of highlighting the targets, which we'll come on to this afternoon. They are out of date. They're now much more challenging, and we'll come on to the specifics later. But the other big change is that both NPF 3 and SPP talk about a desire of a shift to a low carbon society and economy. And again, this afternoon we'll come on to see that there's a more fundamental change in policy and indeed in the law now, which is a net zero. So it's a fundamental shift and change. So NPF 3 and SPP, I would say, are out of date in those respects. And we will see that direction of travel in NPF 4 position statement as we're about to come on to on the agenda. Thank you.
Okay, thank you. And for the council? I think you're on mute, Mr. Campbell. I can't hear you. You're on mute.
Yeah, sorry, no, my fault. I beg your pardon. I think we agree with most of that. It's quite clear that NPF 3, although still extant, is to an extent out of date. And of course, it's entirely unspecific as to location, and that's for this council. That's the most important thing. I have a little bit to say about targets this afternoon, but I don't want to repeat myself. Although the emphasis moving from NPF 3 to NPF 4 is, as Mr. Bell puts it, a shift to net zero or a low carbon economy, that shift is not, of course, confined to electricity generation. And so since you are charged with making a decision about a particular project which is designed to generate electricity, you'll no doubt keep that in mind and not be too swayed by what Mr. Bell calls a fundamental change in emphasis. I respectfully disagree that it's fundamental, but nevertheless it is important to take account of the language that the Scottish Government is using. Unless Mr. Edgar has anything to add to that, I don't think I have anything more.
No, nothing to add to that. Thank you.
Okay, thank you. There's one thing that, just again in preparation for today, I'd be interested. I don't know if we can give it off the cuff view on this, but the references to wild land in NPF 3. So paragraph 3.23 of NPF 3 talks about the need to take into account important features, including wild land. And then paragraph 4.4 talks about continuing strong protection for our wildest landscapes. Wild land is a nationally important asset. It's this question of whether these references only refer to the designated area of wild land itself, or whether it also could be said to refer to, especially as the wild land is given capital letters, whether it applies to land which has wildness characteristics which isn't within SNH's designated maps. And a second question, whether it could be said to apply to proposals that affect designated wild land but aren't necessarily within them. I appreciate I didn't give advance notice of that question, but Mr. Bell, do you have any view to give on that or not?
Yes, I think SPP was published at the same time as NPF 3, and SPP gives effect to the land use spatial policies that flow from NPF 3, and the government has been very clear in how wildland is to be treated in spatial planning, and in particular with regard to onshore wind development as per the spatial framework approach. So we need to follow what the policy says, and it tells us in table 1 in SPP how to approach the matter of wildland in terms of its Group 2 status. And there are other policy references in SPP that we'll come on to later in the agenda, where it specifically examines those. I can expand on that now if that's helpful, or we could wait till that item comes up on the agenda.
We'll wait, thanks. It's just narrowly these particular references. That's fine. Thank you. And Mr. Edgar? Or...
I think in relation to your question was about whether, in considering a development proposal, it's not within the boundaries of a wild land area, do you still consider the impact on the wild land area, if I've understood the question correctly?
Yes, that's part of it, yes.
Yeah, then my view would be that yes, you would. You would consider the impact of a development, it's not necessarily within the wild land area, on the sort of essential properties of that area.
Okay, I suppose my question more is whether that's what NPF 3 is asking us to do. But I mean, it's a matter for our own interpretation.
It'll be a question, so it will also be a question, I think, of the extent to which you regard yourself as bound by NPF 3. I suppose one has to say that until it's withdrawn, it's still extant. But we're probably all at one that it is of waning importance as the time for NPF 4 comes forward. That must be right, because it's consistent with the way we treat development plans. Nevertheless, it is still extant, and if you come to make your recommendation in the next 2 or 3 months, as I'm sure you will, then you'll have to take account of what it says and then construe it for yourself. Did you say 323 was the paragraph you were looking at?
323 and 4.4.
4.4.
Yeah. That's fine. I think we can probably move on. So we'll move on to MPF 4. I'm getting some feedback.
Colin, I just want to just add one context to, I think the MPF 3 text is that it was about that time that the government was, and SNH, as they were then, were discussing the whole concept of wildland mapping. And so effectively the incorporation of the wildland references were essentially bringing that matter to a head at that time and giving it a wider recognition. So in a way that MPF 3 in part probably has more wildland references than it might otherwise have, because it was at that stage that we were going through the stage of the mapping and giving it more of a recognition. And I think in terms of MPF 3, I would say that it sets the context for this is what we are doing and this is why we're going through this process of wildland mapping. And then it's the SPP which really sets then the context for the policies that consider development and the consequences. And 4.4 is very much a scene setter in terms of context. And then obviously the conflicts and the development management are really a matter for SPP. But certainly within the context, MPF was giving this mapping a heightened attention, which hadn't been as high previously. So there's no doubt that that drives some of the context for the statements made. Okay, so it's partly a matter of timing. That's the reason why perhaps wildland isn't given capital letters and there's no direct cross-referencing to the SNH published wildland map, is that they hadn't yet been produced at that time. I think it was yeah, the key point was the precise point. It was going through that phase, and effectively the national guidance and the policy were setting that out and setting a context out for the subsequent mapping exercises which were completed. But the principle of giving wildland a greater prominence was certainly found within those policy documents created at that time. Okay, that's helpful. Mr. Campbell.
Yes, what we must recognise is that although Mr. Innes is right that the mapping process was really beginning at that stage, it was somewhat fuzzy around the edges, and with the passage of time, which is now what, 6 years, 7 years perhaps, the mapping, the sophistication of the mapping of wildland areas has improved. I won't say exponentially, but that's the wrong word. It's improved markedly. So we have a much clearer idea of what we're trying to protect. Of course, you'll be making the decision as matters stand today, not as they stood in 2014.
Yes. Right, we'll move on to MPF 4 then, the emerging MPF 4. And I'm asking there about what indications we have so far about changes in policy the new offshore wind farms. And in any event, what weights I can give to this document, which is clearly at a very early stage.
I lost you there. I'm afraid you faded out there for a second.
Sorry, I'm just really summarising my questions on this item at MPF 4.
No, but I didn't hear what you said. I'm sorry.
Sorry. I was really just reading out the questions that I had there for MPF 4, and I'll come to Mr. Bell first, please.
Okay.
Okay, thank you. I address NPF 4, the position statement, in my hearing statement at section 3.4 in some detail. The question on the agenda is there any indication of a change of policy approach to new onshore wind farms? What I set out is recognition that the government has stated that there's a key opportunity to achieve what is termed a significant shift to achieve net zero. And one of the key opportunities referenced on page 3 is supporting renewable energy development, including repowering and extension of existing wind farms, and new and replacement grid infrastructure. So the policy approach, I would say, in relation to the specific technology of onshore wind, is not changing, it's strengthening, it's providing continued strong support for the technology. So that is the response to that specific question. There's more to say on NPF4 position statement on the next item in terms of the matter of weight.
Yes. Yeah. Well, I suppose not on that point then. I mean, the point's been put that of the 12 objectives, opportunities that set out, it's number 8 that deals with wind farms, and it's not talking about new wind farms. The argument's being put that this could be being read as being more of an emphasis on repowering and extension of existing wind farms.
I think that would be a misreading of it. The government's made it very clear in its onshore wind policy statement that onshore wind is vital to the attainment of targets, not simply repowering. That will not be enough in itself, or indeed modest extensions of wind farms. We know from the white paper, and we'll come on to that this afternoon, that onshore wind is to be a key building block in attaining net zero. There's been no indication at all from the Scottish Government that there is a dilution of support to new onshore wind farm development. So as I say, that would be a misreading of this, and indeed the order of the points does not indicate some sort of priority, because the first item is 20-minute neighbourhoods for urban design and spatial planning, and that clearly in itself would not be
very important.
Very important. I'm not downplaying it, but in itself it wouldn't be a big contributor to net zero, but albeit important. So that is what I would say in terms of item 8 in terms of key opportunities.
Okay, I mean, I suppose it could be said that this NPF4 document is more up to date, it's more recent. It's one of the most recent expressions of policy in this area, and so if a shift was going to be indicated, then this would be the first opportunity to do that.
Sorry, you broke up just when you started speaking there with your question. If you could repeat that, please. Sorry,
I was just talking about how this is the most up-to-date expression of government policy in this area. It's more up-to-date than the onshore wind policy statement. And so if there were argued to be indications of there being a shift, then this would be the first opportunity of it's being expressed.
Well, as I say, I don't think that does indicate a shift at all in terms of lack of support for new standalone onshore wind development. So I just don't think there is any evidence to support that proposition.
Okay, thank you.
Take a different view, but that's my clear view.
No, that's fine. And for the council.
This answer from Mr. Bell exemplifies everything that's wrong with his hearing statement, because it isn't balanced, his answer. It's excessively partial in my submission. What we have at the present time from the Chief Planner in both a paper and a seminar is a document which indicates, I use his word, the direction of travel of NPF4, but he has been specific in setting out that this document should not be taken as an expression of policy or future policy, and we have to wait until NPF4 is published. Now, Mr. Bell has pointed to the fundamental shift towards net zero, and I don't quarrel with any of that. But to anticipate the content of NPF4 is not very difficult, because you can see the direction of travel. But to call it a fundamental building block in the future is, in my submission, an overstatement. Now, what has happened is that the publication of NPF4 has been slower than the government perhaps anticipated, or the bureaucracy perhaps anticipated. And so the Chief Planner has felt obliged to let the community know what is happening, which is done very clearly and very openly by publishing his paper and giving televised video seminars. As an instrument for guiding your decision, it is simply a straw in the wind in my submission at the moment, and not anything stronger than that, not anything on which you could place massive weight. And you shouldn't do that until we see what NPF4 actually contains. It's reasonable to say that there will be continued support for onshore renewable energy. If you marry that proposition with questions of need and targets and fossil fuel generation in Scotland more widely, and in Ayrshire more particularly, then it brings into context the notion that any new development, whilst welcome for its, if you like, renewable content, is hedged about with caveats, principal of which are, of course, the location chosen. So I would just urge you simply, without wishing to make a speech just now, I would urge you with respect to treat the material we have before us about NPF4 with a certain amount of reserve and caution.
Thank you. Mr. Bell, I don't think you commented on the weight that I should give these NPF4 documents.
Yes, and in terms of the weight, I think Mr. Campbell's right. It's a direction of travel, so of policy. It's not policy itself, and the document does clearly say that. But I think what it demonstrates when you look at the context drivers for NPF4, and in many ways it would have helped if we'd had this afternoon's discussion first to set that scene, but we can deal with it today. We would be discussing this afternoon the climate emergency, the green recovery, net zero, the changed law since 2014. All of these matters are referenced in the NPF4 position statement as the key drivers as to why there needs to be a radical shift in planning policy. So the key point, and I can maybe put it this way, is that the planning policy has yet to catch up with the law and the other aspirations that government has set out. And that is why I say the weight to be given to these matters needs to be factored into the decision making in this case. It's not so much a matter of giving weight to the NPF4 position statement. To give it significant weight would not be right, but to recognise that the factors that are driving that shift are valid considerations today and to deserve recognition and weight to be attributed to them. And we can expand on that this afternoon as to when we go into greater detail on those factors.
Thank you. Anything else on NPF4 before we move on to SPP? Okay then. There's a few bullets I've noted down here under Scottish planning policy. Perhaps we deal with the first two together, the presumption in favour of sustainable development and the sustainable development principles. Mr. Bell, I don't know if you're able to briefly summarise your position as to what the important principles are that I should be taking into account in this case.
Yes, thank you. In terms of the first point, paragraph 28, and the presumption in favour of what's now termed sustainable development, it's a simpler expression in the changed SPP of 2020, and I deal with that at my paragraph 3.311. And in terms of how one judges whether or not a development is sustainable, we are directed at paragraph 29 of SPP to look at the policy principles. Not all will be relevant, but a number of them are in this case, and they're there for us to look at. And for example, matters such as giving due weight to net economic benefit, delivery of energy infrastructure, and also protecting and enhancing natural heritage. So there's a recognition that there's a balance of factors to look at there in terms of benefits, but also the effects a particular development may be given rise to come to an overall judgment on whether a development would be sustainable, and as such would then enjoy the presumption. And the position I've set out and the applicant's position is that the development would be consistent and positive with those policy principles, and therefore should enjoy the presumption and the force that that provides.
The changes made recently to SPP and the shift from the presumption in favour of development that contributes to sustainable development to the presumption in favour of sustainable development, does that have any real impact on my decision or the minister's decision making in this case?
I think the reasons behind the change are well known, as set out in the Gladman case, went to the Court of Session, primarily driven by housing, land use planning matters, not renewable energy points. So I think the presumption is probably clearer to understand the way it's expressed now in SPP. So that is what I would take from it in the way I've set it out with reference to the principles.
Thank you. Mr. Campbell or Mr. Edgar, these first two bullets under Scottish planning policy and the presumption in favour of sustainable development and the sustainable development principles. Anything particularly you want to say on these points or in response to what Mr. Bell has said?
I think I'll defer this one to Mr. Edgar, sir. He does deal with this in the Council's hearing statement,
yeah,
at a little length, and I'll just get the paragraph number. But could I invite him to contribute?
Sorry, I'm in trouble finding my papers there.
Fine.
I'm just going to have to ad-lib it. In terms of the presumption in favour of sustainable development, as Mr. Bell mentioned, this is primarily in relation to housing, and I think all that it does do is just clarifies that it's quite clear from the words and from the chief planner that it's to clarify that nothing in those statements in paragraph 28, as previously worded, was to suggest that planning authority should be approving something that's unsustainable. I think that statement just clarified it, that we've assessed things as whether they're sustainable development or not. In terms of paragraph 29, as Mr. Campbell said, or so you said yourself, not all these criteria or policy principles are relevant, since they cover the whole gamut of development, potential forms of development. Sure, so the question was to identify which ones were significant.
Well, I mean, I've seen you. I think you're right that, I mean, we can see the references there to landscape and so on. Yeah, it's probably not helpful for you to go through the list and tick off the ones that you think are important. So I'm happy to move on.
So just for your notes before you move on, the Council's hearing statement, chapter 2.2, takes 2 pages to walk through the paragraphs SPP which bear on this question, starting at paragraph 1, and it doesn't take them one at a time, but it takes 4 or 5 examples from the document right through to paragraph 202. It might be just worth reminding ourselves what that says, that the siting and design of development should take account of local landscape character, with decisions taking account of potential effects on landscapes and the natural water environment, including cumulative effects. As reasoned within the regulatory panel report and subsequent supporting information submitted in respect of private water supplies, it is not considered that the development proposal accords with this statement. That's to say, the statement about contributing to sustainable development. So somewhat against the flow, this is a council which is saying this is an interesting development, but it is not sustainable for the reasons we give. And therefore paragraph 28 doesn't apply. It's not often that you see a council taking that position, but that is the council's position in this case.
Thank you. If we can move on to the parts of SPP that are dedicated to renewable energy then, and paragraph 154, and here we've got targets again, which are talking about 2020 targets. We're beyond 2020 and things have moved on somewhat. So I suppose it's a similar question to the question with NPF about what I am to do with that first bullet at paragraph 154. Do I just ignore that now, or do I assume that the new targets can be parachuted in here and have the same effect and impact on decision making? Yeah, Mr. Bell, any view on that?
Yes, I think as I said 2014, and the law has changed as well in terms of emissions reduction targets. So we'll come on to those specifics this afternoon, so you can see what the different ones are and where we are against them. Mm-hmm. And the other key point is that this title of this chapter is a low carbon place.
Is that a dog somewhere?
Doesn't like my answer clearly. So the title is a low carbon place, and we now know that we are going to a net zero place in the future. So it's out of date in that respect. So I think NPF 3 and SPP, Mr. Campbell's right, they're extant, we need to deal with them, but they need to be viewed in that context. I think he used the term waning in some respects. So I think we're not in disagreement on that. And when you look at the position statement and you see the direction of travel of policy, that underlines how out of step this planning policy position from 2014, which was probably consulted on in 2012, 2013, way back then, is simply not aligned with today's society and objectives in many ways. And I would just finish by saying that we can see the fundamental focus that NPF 4 has on net zero and prioritising emissions reduction and renewable generation, and that is clearly a difference.
I suppose coming back to, I should have asked under NPF 4, which is going to supersede SPP. What's the latest information we have on the timing of when a draft of that may be coming out? Is it this autumn?
Yes, my understanding is September. I think there was a chief planner letter a few months ago that indicated that was the programme, and I don't believe there's anything issued since then that's contradicted that date. So sometime in September it goes back to the report.
Clearly that will still be a draft document at that stage, but would it be the applicant's view that it would be wise for me to seek further views from parties once that is published? If it's
yes,
published before I make my recommendations.
Yes, I will leave it to the advocate acting for the applicant to confirm that, sir. But from a planning perspective, I would say that it's conventional that as a document gathers more progress, that the greater weight is attributed to it, and we will see with some confidence how the government is setting out the new spatial planning approach for onshore wind, because the government makes it clear in the position statement that they're deferring the spatial planning approach for wind to the draft NPF4, because we don't get much insight into that in the position statement beyond the headline points that we just discussed earlier.
Okay, thank you. Turn to the council then. Both coming back to that point about whether you think I should be seeking views on the draft NPF4 if it emerges, and also what to do with these targets that I see at paragraph 154 of SPP at the moment.
I've got reservations about delaying decision making to await the publication of an official policy statement. If NPF4 is coming forward for a public consultation, but also a parliamentary discussion, on balance, sir, I would respectfully suggest that it's likely that its publication in a final form may be considerably delayed into 2022. I don't know that, of course, but that seems likely given one's experience with parliamentary procedures. I don't want to advise you to ignore it if it happens to come to hand when you're writing your report from ministers. But at the same time, speaking for myself and not really for the council so much, it seems to me that there is merit in prompt decision making, as we're called. Court always calls it good administration. And I'm sure that's true from the developer's point of view as well as from the public's point of view. If I could draw your attention quickly to the council's hearing statement at 2.2.4, the council acknowledges that it is supportive of the transition to a low carbon economy consistent with whatever national targets and objectives are. But it also gives itself a bonus point by recording that it has hitherto, in support of those objectives, consented large-scale wind, onshore wind planning proposals in its locality since these became a reality. Indeed, so this is South Ayrshire Council's first public inquiry into a wind farm proposal. It emphasises in the second part of paragraph 2.2.4 that, in its opinion, these objectives must be tempered by the rather worn phrase now of the right development in the right place. And as you know from the evidence you've heard, its opinion is that this is not one of those. I don't think I'd like to go beyond that, perhaps Mr. Wood, but I have nothing, I don't think, to add to that.
Thank you. Then should we move on to the spatial framework then? Group 2 and Group 3. And I think there's a difference between you about how I should be considering the proposal. Turn to the applicant first, and I think your argument really is that I should, to all intents and purposes, be treating this as a Group site. Is that correct, Mr. Bell?
Sorry, you just, I didn't catch your very last bit of what you said there in your question. Sorry,
I don't know if it's dropping out or at your end, but we'll keep going and hopefully it won't get any worse. I was referring to the spatial framework in SPP at table 1, and I was characterising your position as being that you thought, to all intents and purposes, we should be considering the application site as a Group 3 site. and I was asking you to confirm that was correct and perhaps explain why.
Yes, thank you. I think technically the site is a mix of Group 2 and Group 3 coverage when one looks at the mapping, the 2016 carbon-rich soil priority peatland mapping. And that is the national level mapping that SNH provided and then planning authorities have used for the purposes of spatial framework. So it's a crude strategic level of mapping, but it gives a fairly good idea of where the carbon-rich soil resource is. And we know from the spatial framework approach that the government said, look, Group 1 areas is an embargo, no wind development in these areas. It said for Group 2, which includes things like wildland, as a mapped interest and also peat, it's almost like an amber light. These are important national resources. We're not saying wind farms cannot be developed in those areas, but one needs to go about it very carefully so that there isn't an unacceptable impact on those resources. So the approach has been, and Mr. Darnborough will come in just after me to just give a brief explanation on the design approach that has dealt with this consideration. That because of that design approach, the scheme, the infrastructure layout has been created and sited in such a way that it does not have a significant effect on that resource, or put in the term that SPP Group 2 uses, any significant effects have been substantially overcome. And if that is the case, and the applicant's position is it is here, and indeed SEPA is content with that approach, then that consideration has been satisfactorily addressed. And that situation's arisen in some other cases, and I'd given two examples, one called Clauchrie Glen, which is a Scottish minister's decision, CD 6.24 in Argyll, and another case in Highland called Knockanice. The latter one was Mr. Tim Bryan was the reporter, and that's CD 6.23. And the reporters accepted the position that once the Group 2 matter, i.e. carbon-rich soil, had in those cases had been satisfactorily addressed, then the site could be regarded as having Group 3 qualities, although the base position would be that technically it is a mix of Group 2 and 3, but it could be regarded as effectively Group 3, in which wind farms are likely to be acceptable, subject to consideration against detailed development management criteria. So I thought it would be helpful to reference those cases, because these are exactly the circumstances that we have in this case.
Okay, thank you. Do you know if we have the SNH high carbon soil mapping before us at this inquiry? Is it one of the documents?
I think it may be useful if Mr. Darnborough comes in at this point to expand on that, because he will have started off by using that mapping, and then that was of course supplemented by a much more granular analysis of peat resource based on the EIA assessment.
Okay, yes, let's hear from Mr. Darnborough then.
Good morning, sir.
Good morning.
I thought I would start perhaps by giving an overview of the work we did looking at peat as part of the environmental impact assessment, if that would be helpful.
Yes.
Yeah. So as part of the EIA, we did an extensive investigation across the site, and this, as Mr. Bell has said, was based on an initial desk study to look at the mapping, the class mapping across the site. We actually undertook 1,950 peat probes across the site. So we collected extensive data to support our original analysis based on the mapping. So we know the extent, presence, depth of peat across the site. And what we found was that it was observed to be disturbed and modified by the presence of tree roots, and in some areas uprooted due to wind blow. There was numerous drainage ditches observed across the site, So the site was that had been heavily impacted by forestry. The ground conditions were significantly impacted. So overall, the occurrence of deep peat is variable and intermittent across the site and located mainly in the southwest and localised in areas of the centre and east and separated by extensive areas of shallow or no peat. So taking that data, we then use good design principles to avoid areas of deep peat. And so the siting of most turbines, tracks, and other infrastructure, resulting in a design which minimises the impact on peatland habitats.
Okay, thank you. Yeah, Miles, I looked at if you've got the EIA report handy. I'm just thinking about where I can get the most authoritative information about where peat is on the site. And figure 7.6A of the EIA report, that's the result of your peat probing exercise, I take it.
Yes, that's correct.
So should I regard 7.6A as well, can you tell me about figure 7.5 and where the peat mapping there comes from? Is that from the British Geological Survey?
I'm just checking. CD 1.2.28, sir. Is that correct?
I'm looking at the hard copy, but it's volume 2 of the EIA report.
Yes.
Which is the report.
Yep. Yep. This is the 1 to 50,000 superficial geology.
Yes.
British Geological Survey. That's correct. Yes.
Could you repeat the number, Mr. Darmer, please?
The number is CD 1228.
I'm much obliged. Thank you.
I mean, they're quite different, the two maps, but you're presumably obviously the British Geological Survey didn't involve the in-depth investigation to the same degree that you did. And so
I didn't hear all you said, but I think.
Sorry, am I breaking up? Can people hear me?
No, you're breaking up.
I'll switch my video off. Is that better now?
Yes, thank you.
I was just asking Mr. Dunbar if he's confident that I can take figure 0.76A as that's the best information I have on where peat lies on the site.
Yes, absolutely. Yeah.
Okay. Okay, thank you, Mr. Darnborough. I can come back to the council then. Just this all came out of the discussion about the spatial framework and Group 2 and Group 3. So have your view, please, on how I should consider the application site in terms of the spatial framework.
Thank you. I think I'll respond to this, John. The council opinion that the site lies within an area of significant protection in terms of the spatial framework contained within supplementary guidance. Site lies within an area where there's a prevalence of carbon-rich soils, deep peat, and priority peatland habitat. The data has been mapped within our document. It's mapped at a fairly strategic scale. Obviously, we can only use the data that's available. We wouldn't have the resources to do these detailed in-depth survey that the applicant was able to do. So it's not intended to be used at a field boundary level. So the information therefore indicative and is used to identify broad areas with this characteristic. We acknowledge that the detailed survey work done by the applicant and that the scheme was developed to avoid being in areas of peat. Our view is we still categorise into two, because what that does is it draws attention to the fact that there is an issue with peat, and that was then investigated through the supporting information with the application, and acknowledge it's been designed to avoid damage to the peat. But we still regard this as being category 2. It highlights the issue around peat. So it's appropriate to still consider it as category 2.
Yes, I mean, to some extent, there's a bit of a fluid boundary, isn't there, between the two? Because even if it's group 2, I can still consider wind farms appropriate if the qualities are substantially overcome, and even if it's group 3, I can still consider peat in the detailed consideration against policy criteria. So in some ways, this isn't really a hard boundary. Is that correct characterization, Mr. Edgar, do you think? Okay, Mr. Edgar can't hear me, but maybe that question to the applicant.
Well, perhaps I can,
Yeah, Mr. Campbell.
Able to contribute to this, picking up what he said, the council's view has been that this is a group 2 site, because not only is there widespread presence of peat, and of course I acknowledge the mapping that's been done and the probing that's been done by ITP, which is pretty comprehensive. We were concerned, I think you might remember last week, with turbine 13 in particular, which is to the north of the site, in which the witness acknowledged that the excavation of peat would be necessary, although it's just shown off the edge of the dark brown area, I think, in this particular map.
Yes, I see it.
You'll remember the evidence that came forward about wave damming and the excavation for that particular site and the formation of roads. So the question is, perhaps for you, sir, and this may be dealt with in closing submissions. Can you pick and choose in a peat-rich site? Can you pick and choose areas where there is no peat in order to site wind farms? Or must the site be looked at spatially, which is what this map is, and regarded as a carbon-rich soil, which should be avoided? I think you know what the council's position is.
Okay, thank you. Anything further from the applicants to come back on this?
Yeah, colonists on behalf of the applicant. In terms of the policy test, has it been substantially overcome? And the issue is that in our submission, it absolutely has. The whole question of peat on the site was methodology was fully agreed with SEPA prior to the submission of the application. The consultation responses have come back. This is an issue which is regularly has to be dealt with in onshore wind farms in a Scottish context, given the nature and character of largely where the areas are for this technology are likely to be deployed. Therefore, both SEPA and the Nature Scot and other organisations have extensive experience in evaluating the results of peat survey work. And in the context of what's been undertaken here is we have a very detailed survey. So we understand two aspects. First of all, we understand the nature and depth of peat and where it appears on site. But we've also undertaken an analysis of the peat resource itself, because it's not just about peat depth. It's also been substantially degraded by the current land use, which is commercial forestry, direct impacts from forestry, and also the indirect impacts of the drainage associated with forestry. All those matters have been fully evaluated, and the layouts have effectively been submitted to the relevant consultees, and they have all commented and found the matter satisfactorily dealt with. And that also includes, obviously, the specific issues with peat slide. So in these matters, this has been given a very careful attention, with a lot of detailed survey work, and a lot of subsequent evaluation, not just by the applicant, but by the consultees and also the Scottish Government's advisors on peat matters. And all those consultees have come back with a satisfactory outcome. I can't see how, in any other ways, we can demonstrate substantially overcome threshold of Group 2, other than the processes that we've been through. And in my submission, we passed the policy test with flying colours. And indeed, with our habitat management, we'll be putting something positive back as well in relation to this particular aspect, in the sense of we will be enhancing areas which will become more valuable habitat, and will be genuinely the carbon-rich and deep peat soils, which are recognised as being an important attribute. So that's the applicant's position. Not only do we meet the test of substantially overcoming it, but we've taken opportunities because of the expertise of the applicant and the background of their team to look at opportunities for positive enhancements as well.
Okay, thank you. Can we move on to paragraph 169 then, which is the list of development management criteria to apply for energy infrastructure development. And I'm particularly interested in the net economic impact bullet at the start there. And it goes on to say some things that net economic impact can include, but that may not be an exhaustive list. And I suppose it's how narrowly or widely am I to consider net economic impact here? I mean, in some of the submissions, it seems to be suggested that I could draw it very widely and include aspects as wide as the benefits to Scottish industry of having power, or the impact of Scottish taxpayers having to pay for constraints payments and so on. Whereas probably my experience in the past of dealing with wind farms has been a slightly narrower definition of looking at things like the employment benefits deriving from the scheme balanced against local tourism impacts, for instance, a more narrow consideration. So perhaps starting on that point, Mr. Bell, I don't know if you've got a view to give.
Thank you. I think just your first point there, sir, about Scottish industry, does that come into the frame? I would say yes, very much so. There is sometimes a temptation just to look at the development itself and what it provides, but the onshore wind policy statement makes it clear that the Scottish Government sees as an important objective of maximising the economic opportunity, and that is at the more regional and national level, insofar as the supply chain opportunities are there to be maximised. And the benefits are set out in my chapter 5 in summary, and I've drawn upon the evidence presented in more detail by Mr. Blackett, who you heard from last week.
Yes.
At the hearing session. The other example you gave was constraint payments, and I think this is maybe coming from Mr. Kelly in his evidence, and I would say that is simply not a matter that is relevant and I can give this afternoon, it's on the agenda, and I can give you the reasoning for that rather than taking up too much time now. But I think that that would be wrong to take that into account in terms of any constraint payment or grid operational matters. SPP is very clear on how one should treat that. The benefits set down are net additional benefits. So the project is not displacing benefits or trade, if you like, from elsewhere, and there are no significant economic costs. I think, as Mr. Blackett put it in the hearing statement that I viewed. So that's the position. The benefits are set down in my chapter 5. Mr. Blackett provides greater detail, and it's an important consideration as set out at paragraph 169 of SPP.
Yes, thank you for that. No, I don't want to go into all the detail we went into at socioeconomics hearing. That's correct. I suppose it's just my feeling that the more diffuse the costs and benefits are away from the site, then the harder it is for me to make a useful assessment of it. And I've got the information in the EIA report about such matters as direct employment from the site, and that's a more straightforward thing for me to take account of than these very diffuse benefits there may be to the Scottish economy, or indeed diffuse damage done to the Scottish tourism brand as a whole, that sort of thing. But sorry, Mr. Bell, I'll let you go.
Sorry to interrupt. It was just to not to lose the train on the more diffuse points that you mentioned, but in the onshore wind policy statement, which, sorry, I don't have the document reference immediately to hand, but in the introduction of the ministerial statement at the start of the onshore wind statement, the third last paragraph, the minister says there is no question that onshore wind is a vital component of the huge industrial opportunity that renewables more generally create for Scotland. And it goes on to talk about the number of jobs supported in the sector. Now, we also know from the evidence of Mr. Blackett, and some of it is set out in my evidence in terms of the green recovery from the pandemic, that the advice the Scottish Government has received from the Committee on Climate Change and also the Government's Climate Emergency Response Group is that it is these types of projects that are coming forward now that can be potentially consented in early course that will deliver the green recovery, that will move into construction, and that will create those benefits and add to the agglomeration of that wider industrial opportunity. So yes, I would say it is diffuse. It can sometimes seem rather secondary, but it's only by the sort of collective mass of projects that weight of benefit will be realised at the national level. And I think that's what the Minister is setting out so clearly in the onshore wind policy statement back in 2017. So that was the position back then, and the situation now in terms of enjoying that economic benefit is clearly much more pertinent in today's circumstances.
Okay, thank you. Mr. Campbell or Mr. Edgar, whoever wants to speak on this issue of net economic impacts and how I should interpret that.
The Council deals with that at 2.2.7 of the hearing statement and reflects that the considerations which are bulleted in SPP are also reflected within the local authorities' development plan policies. I'd be happier if Mr. Edgar were to speak about these, but you will have looked at the regulatory panel report and you will have seen that this development is assessed against the local development plan policies.
Yeah,
it's not my place today, whether I have views or not, to comment on the wider and more diffuse issues which Mr. Bell has touched on. When I say that, I mean as a representative of the local authority.
Understood. Mr. Edgar, are you able to participate again?
Sorry, sir, I'm having quite a lot of problems here with my computer. I keep losing the sound. I get some sort of interference. I'm just trying my best to continue listening, but I'm struggling a bit here at the moment.
I can hear you fine and I can see you fine, but is it more the problem that you can't hear us?
Yes, I don't know what's happening with my computer, but I'm getting interference. It's something to do with my setup here. So I'm just really struggling to follow the discussion at the moment. I apologise for that.
Mr.
So I think,
Campbell.
as far as what Mr. Bell has said, it's not the place of a local authority to make submissions about what may happen across the rest of Scotland or about ministerial statements. It doesn't matter whether I have views or even if Mr. Edgar has views. The local authority's position is clearly set out in its hearing statement. And we'll come to hear about the local development plan and the modified local development plan in due course in this session. But for now, I would like to content myself with, I'm content just to rely on 2.2.7. And if necessary, I can reapproach this matter in my closing submission if there is something to say on behalf of the council. You'll appreciate that with a restricted remit like that, it's not appropriate to embark on a widespread discussion about Scotland-wide issues if you're a local authority. It simply isn't.
That's fine. I just didn't want to. I wanted to give you the opportunity to comment. If
No, I appreciate it.
Thank you. Feel left out. Yeah. Are we concerned about Mr. Edgar's? Well, we are concerned about Mr. Edgar's difficulties joining in today. Are you content that we continue, with your involvement and Mr. Edgar as far as he is able to?
I'll have to get a fee for it. A fee as a counsel and a fee as an expert today.
Well, I'll let you negotiate that separately.
I think if Mr. Edgar, I'm assuming you're going to break shortly, and I'll have a private conversation with Mr. Edgar to see how difficult it is. But for the moment, I'm fine for you to carry on, sir.
Okay, well, we'll continue on to the end of item 8, and then we'll have a break.
Thank you.
And the only other point I wanted to raise on paragraph 169 was about cumulative impact, which is the 4th bullet. And then cumulative impact is defined in the glossary to SPP as including undetermined applications. Now, reading reports from colleagues and so on, and cases I've done in the past, I think it's quite common practice to give suddenly give a lesser weight to proposals that are in the planning pipeline but haven't yet been consented, let alone built. But I am conscious of that definition in the glossary to SPP. So I just would be interested in parties' views, starting with Mr. Bell, on the weight I should give to proposals at different stages in the planning pipeline.
Yes, I think the landscape and visual impact assessment for the project has clearly addressed cumulative matters, and you will have Mr. Welsh's evidence on that. The weight to be attributed to projects at different stages, I think, is a sensible one, and as you say, it's reflected in the glossary of SPP. If a development has planning permission, that attracts more weight than if a scheme is just at the scoping stage, where at that stage the number of, if it's wind, the number of turbines, the layout can fundamentally change. So that's the reasoning why weight should be, in my view, attributed in that way, and I think SPP picks up on that. The reference to cumulative in the 4th bullet of 169 is, though, not just about landscape and visual, it's all considerations listed at 169. So one matter that sometimes come up is traffic. There was a case in East Ayrshire where there was one access road, one public road, but more than one wind farm being developed off it. So that was giving rise to cumulative traffic issues. We don't have that here. But the point is, cumulative issues can arise with other topics, whether that's noise, traffic, or landscape and visual, but all cumulative matters have been satisfactorily addressed in this case.
Okay, thank you.
I'm just going to add to David Bell's point there is that insofar there's 2 points here. There's the first under the relevant environmental impact assessment regulations of the duty to assess and report on cumulative impacts. And clearly that duty is quite extensive. And there, so it's very important in decision making, there's 2 aspects where cumulative comes in. The first is in that EIA process, and given the importance of having to reach reasoned conclusions, there's an element in there that's pretty critical in terms of recent case law, is making sure you've taken them into account, i.e. you've considered them, and that's a really important part of that EIA process. And this second point is saying these are factors to take into account and to have regard to. And I think really what it is setting out is that you've got to make sure that you've considered cumulative effects and impacts. And there may be circumstances where cumulative effects are important drivers in the actual overall decision making. It doesn't specify when and how. That's ultimately a matter for individual assessment and consideration at a project level. But in this context, it's clear that it is a consideration in terms of this policy and a requirement to consider the issue. In terms of weight, our position is that clearly any project that's sitting behind the application, our application determination, will have less weight, and the further behind it has less weight. In terms of the actual crunch, in terms of reaching a conclusion, it's clear that in terms of, whilst cumulative impacts are a key part of the assessment, to get it to the level of being a determining factor, one has to have levels of impact on a cumulative scale that result in an issue in terms of determination. And I think that's really where you cannot really set a policy for that. That's a matter of judgment based on the information relating to the specific project.
Okay, thank you. I mean, I don't know if it partly relates to cases where perhaps there are 2 competing wind farms in the same piece of landscape, an area with limited landscape capacity, and there are 2 competing schemes, one slightly behind the other. Maybe the factors would be slightly different from here, where there's a degree of separation between this proposal and any other current proposal. Anything else anyone wants to raise about paragraph 169?
Sir, I agree with what Mr. Innes said about the amount of weight to be given to another project will depend on its place in the sequence. Somebody once said there's no level playing field in planning, and they don't all get the same weight. There are different kinds of cumulative impact, not just landscape and visual, but noise, traffic, and whatnot. So I agree with all of that. We would say, I think, in South Ayrshire Council, that these are matters that have been considered in the report to the regulatory panel and reported on already. And we don't find, aside from the conclusions on cumulative impact on landscape and visual, we don't find anything in the environmental statement which is worth detailed criticism and analysis. In other words, we broadly are in agreement that the correct approach has been taken. I think I'd be repeating evidence that you've heard already if I said any more. So unless Mr. Edgar's got anything to add to that, I would just leave it there, I think.
Okay, thank you. My only other point on SPP was coming back again to wildland, and maybe we're repeating what we said in our discussion on NPF. Paragraph 169 talks about effects on wild land. So it's this question of whether that means that that includes effects on wild land from development outside the wildland. Whereas paragraph 200 of SPP, if I can come down to that, seems to be limited to the geographical area of the mapped wildland itself.
I'm sorry, you dropped out there for about 2 minutes. I didn't get any of that.
Oh dear, this isn't. This is poor. I've been using the same link the last few sessions, and it's been fine. I'm talking about wildland. Can you hear me now?
Yes, indeed, sir. Thank you.
I'm talking about wildland, and I suppose I'm contrasting the approach in SPP between paragraph 169, which talks about the effect on wildland, and arguably could be extended to effects on wildland from development outside the wildland, and comparing, contrasting that to paragraph 200, which seems to be limiting the consideration to the areas that are actually within the SNH map. So, Mr. Bell, is there any contrast to be drawn between these two references, or are they saying the same thing?
They're saying different things here. I think there's 3 paragraphs that we need to recognise. 169 to start with, where wildland is one of a number of considerations, and there is no particular weighting given to the matter there. We do know, of course, we discussed earlier, it appears as a Group 2 consideration in terms of the mapped interest. We'll come back to that. But paragraph 200 is a statement about wildland character in relation to all development types, not just wind energy. But it goes on to reference that plans should identify and safeguard the character of areas of wildland as identified in the SNH mapping. So it's very much about a direction to planning authorities with regard to plan making. It sets out the approach insofar as it's a Group 2 interest. And I think, as Mr. Innes said at the start of the session, when we think back to 2014, there was the core areas of wildland had been analysed. We had the new mapping, and so planning authorities were setting out, preparing new development plans in line with the new national planning policy. Very much part of that new, fresh approach that was being taken. So, moving on to paragraph 215, that simply deals with in situations when a development is in wildland, and there have been a number of cases where that has been thoroughly examined, and that is fairly wide consensus now that paragraph 215 sets out that in areas of wildland, development may be appropriate in some circumstances. So it's not embargoed even in wildland, but that test of substantially overcoming effects is engaged if one is promoting development in wildland. So that leaves us with paragraph 169. I would agree that the effect of development on wildland, if the development is out with wildland, is relevant, and that has been assessed in this case. So it's 169 we deal with, but as I say, it doesn't give us any indication on the matter of weight to be attributed to that consideration. It's one of many of 169.
Thank you, Mr. Bell. I don't know if we've now lost Mr. Campbell. I'm seeing a little symbol next to your box, Mr. Campbell. Can you hear us? Mr. Edgar, can you hear us?
Yes, I can.
Do you have any view on this issue of SPP's treatment of wild land?
The council obviously assessed wild land in detail in its report of handling, and we've taken the approach that the development the impact of development out with wildland should be, sorry, the impact of development out with wildland should be taken into account, and that would be our interpretation of SPP.
Thank you. I'm aware that Mr. Campbell doesn't seem to be with us at the moment. So I think perhaps what we'll do now is we'll take a short break and see if he comes back. So let's break. We'll deal with the final bullet at 8 and then go on to item 9 after we come back. We'll just take 10 minutes to give Mr. Campbell a chance to sort out, and perhaps Mr. Edgar and myself even, to sort out our difficulties, and then we'll come back at 25 minutes to 12, please. Thank you.
Can you hear me now, sir?
Mr. Campbell, I can hear you okay now. I think it must be some connection somewhere with itself.
Obviously, it's some connection. I could hear Steve and yourself perfectly well
Yeah.
before the break. And I can see myself quite well, so and see David Bell. So I don't know where the fault is, but anyway.
Yeah. Hopefully, it's okay now.
As long as the reporter can see us, that's the main thing.
Yeah.
Yes, I've got the advantage. I can see you, but you can't see me, which is perfect as far as I'm concerned.
I think there's a big question of natural justice there, so formally subject to a separate monograph later on.
I think I will continue without my video, just for the risk of further problems today.
Well.
Right, welcome back, everybody. So we were just closing off item 8, just with the final bullet, and that's just me asking the question about whether carbon and renewable energy benefits are already priced into the policy context. Mr. Bell, do you want to give me your view on that final bullet there, please?
Yes, I mean, my assumption was that this was maybe prompted by some of Mr. Kelly's positions on benefits, because that's the language that he uses. So it may be he wants to respond to that. But what we've discussed this morning is that the policy has been changing, and indeed the law has changed. So I don't understand the point of pricing in, or what really that means. So as I say, Mr. Kelly will need to maybe explain that. But if what he's saying is that NPF3 and SPP have all we need in terms of energy policy and how we need to look at the benefits of a development, and there's no need to look beyond those documents, I would say that is wrong. And I set down in my hearing statement reference to 3 cases that I think are quite helpful in explaining the additional weight, if one puts it that way, that can be afforded to the benefits of renewable energy that has been recognised in other decisions. And probably the better one is Paul's Hill 2, which is CD 6.16. So happy to go to that to further explain my point. It wouldn't take very long. It's just a very brief, fairly brief reference to it. It's in my hearing statement at paragraph 2.2.29, which is page 14. And the reporter in that case, it was a section 36 inquiry report, said, I find the support this proposal can draw from SPP has been strengthened. And he goes on to mention additional points. Firstly, by the publication of subsequent policy and strategy documents, such as the onshore wind policy statement and the Scottish energy strategy. And then secondly, he says very recent changes in legislation, and that will be the 2019 Emissions Reduction Act. And then he goes on, thirdly, to say further support can be drawn from the clear recognition by the Committee on Climate Change that with the need for much greater progress on carbon emission reduction in the future, which has led to the declaration of the climate emergency. So it just illustrates the point that we cannot just rest on NPF3 and SPP. There are other material matters that are relevant for a decision maker to take into account and to afford weight to as he or she decides. I would say there's not a pricing in of benefits.
Thank you. Mr. Kelly, do you want to come back on that? I see you've joined the discussion.
Thank you, sir. The point was really a very, very simple one, and Dr. Gordon has picked this up too in this case and other cases, and that is that many of the asserted benefits of wind farms are generic in that they would be delivered by any wind farm anywhere. and therefore that is why the policy is generally supportive of wind farms having regard to those factors. The issue for you is the additional benefits of this particular wind farm. So I wasn't going beyond that. I wasn't intending to go beyond that very simple point that many of the asserted benefits are generic in that they would be delivered by any wind farm anywhere, and therefore ultimately the council's position, I think, is the correct one, that this is a locational decision that has to be made. So a very simple point, sir.
Okay, thank you. Mr. Bell, would you agree with, would you go that far?
I think it's almost bringing in a point that this doesn't really matter. There's other developments elsewhere that are coming forward. I get that impression. I think the key point is that the projects need to be delivered, and we'll come on this afternoon to look at the delivery point and what that means in terms of other consented developments that simply aren't going anywhere. They aren't being delivered, and the applicant's track record of delivery of real projects on the ground being implemented. I think the other point is about the benefits in essentially what we will see from the white paper and some of the other documents is that there's a real urgency to delivery. It's as much as we can get, as fast as we can get it. Of course, within environmental limits of acceptability, that has to be a balancing consideration. But the new position, if one puts it that way, for energy and looking ahead to demand forecasting for electricity, which has to be renewable electricity, means that the benefits are seen in the context of the future demand profile, not simply what they were back in 2014.
Okay, thank you. Mr. Campbell, Mr. Edgar, anything from the council on this point? Right. I think you're possibly on mute there, Mr. Campbell, but I think you were saying no.
I'm sorry, that's twice I've done that today. No, nothing from me. I don't know if Mr. Edgar has anything on that point. It's
Yeah, I think
for the reasons I gave earlier, it's not appropriate for a council to be heard on matters of this kind, I don't think.
Okay, then, shall we move on to item 9, national planning guidance? And we've got the onshore wind turbines guidance from 2014, which I think is the online advice sheet. And I say there, I have no particular questions in relation to these documents, but inevitably I now do. So if we could possibly turn to that document, I can find it myself. I think it's CD 4.3. And page 6 of that document. And there's a reference about halfway down page 6 to buffer zones. And it says buffer zones should not be established around areas designated for their natural heritage importance, and proposals should be considered on their merits. I suppose my only question here was, is the correct interpretation of that a buffer zone as a no-go area shouldn't be established, say around a national park, where you say no wind farms should be allowed in national parks, and then a subsequent policy comes along and say, well, here's a 5-kilometre area around a national park, and there shouldn't be any wind farms there either. But there would still be an allowance for policies that sought to protect the impact on a national park of wind farms that were developed outside it. If that makes sense to Mr. Innes, I don't know if you've got I see you've come up now, so I don't know if you've got a comment on that.
Yeah, yes, sir. There was quite a long-standing position of Scottish Government about not having buffers around designations. And I think the idea was that there was a danger that effectively what we would have is not only designations, and if you look across Scotland as a whole and look at the scale of national scenic areas and national parks, if you then add buffers around those, you start, and those are areas which have accommodated fairly significant onshore wind development, that effectively that would stifle the opportunity to consider potentially, exactly as you say, projects that are not within the particular designation, but are outside and do not adversely affect the particular designation in a manner which would undermine the reasons for designation or the balancing policies that are set out in SPP in relation to national scenic areas, etc. And I think all this was a statement of we don't think it's appropriate to have buffers around natural heritage interests. We feel that the proper way to deal with it is to assess the particular project and its impact on the particular resource, and that's effectively that would cover biodiversity designations as well. So effectively, it's just a straightforward statement. You shouldn't have buffers around the designations, and you should consider each project on its merits in relation to those matters. And I think it's as simple as that. I don't think there's much more that can be said, but I think there was a concern that effectively would start having 10-kilometre standoffs to national parks or national scenic areas, and then there'll be a variety of responses on buffer zones. Others would put it further, and that was really what was being stopped by this statement contained in this guidance, because of the consequences that it would potentially have for the deployment of onshore technologies within Scotland. And I think it does recognise, however, that the Scottish Government, even back then, was recognising the likely need to locate onshore wind projects in proximity to designations. That was almost an inevitability of the target that was then being set for 2020. And effectively, it was inevitable that some land would need to be found in and around designated sites to accommodate and deliver the onshore wind to support that policy objective. And there was a concern that if they didn't put this in, that development plans would potentially frustrate that through buffer zones.
Thank you very much. That's helpful. Mr. Campbell, Mr. Edgar, nothing to add?
I don't know.
No. Okay. My other question on the online advice sheet was at page 9.
Sorry, which page was that?
Page 9.
Thank you.
And it's coming back to cumulative impact. And it says in the second sentence there that cumulative effects likely to become more pertinent in considering new wind turbines in areas approaching their carrying capacity. And then the next sentence says, in other cases where proposals are being considered in more remote places, the thresholds of cumulative impact are likely to be lower. I was wondering if those two sentences are meant to be being read together. These are two sides of the same coin. There are, on the one hand, remote areas, and on the other hand, areas which are approaching their carrying capacity, or if it's making two separate points there. And I suppose more generally, parties' views on whether it may be more of a landscape point, but for the landscape section, but whether in this particular case, I should be considering this application in terms of that first or second sentence there, that about this being an area which is approaching its carrying capacity. Mr. Bell, I don't know if you've considered this paragraph before and its meaning.
This is part of the overall policy review, and I think it simply expands slightly on what we have in SPP in terms of the reference to cumulative impact, and it's giving some suggestions on the circumstances that may arise, although it's not very specific, it's still fairly general. I think in terms of capacity, we know that landscape capacity studies have been prepared, and there's now a move to consider them more as sensitivity appraisals. That gives us some guidance. But I would say that this is simply giving us the various circumstances in which cumulative effects may arise. And beyond that, one needs to look at the specifics of the cumulative appraisal within the EIA report.
Okay,
Yeah,
thank you, Mr.
Colin,
Yeah,
there was one point I was just going to make, is that the online guidance has been around for quite a while. Prior to the current form of SPP, there was previously a basis on which local authorities, in preparing guidance, could effectively identify areas where the cumulative threshold had been exceeded, and were therefore able to essentially add that as a sort of significant constraint in relation to further development. And effectively, the SPP superseded that in terms of its spatial frameworks. And that was a change in approach advocated in SPP. Some of these comments and the wording around this seems to very much be around some of the thought processes that were in place in relation to those studies which councils could undertake prior to the current SPP in establishing areas of constraint for wind farm development. And therefore, I think that advice is probably primarily targeted at that. But in terms of does it help you reach a view on how you should treat cumulative impacts, I don't think it really does, because it doesn't set a threshold. It just says in certain areas you're likely to have a higher ability to accommodate wind farm development because of lower underlying sensitivity. But in very remote areas, it is likely that significant volumes of onshore wind may not be accommodated without having greater effects in terms of that character. But I thought it was helpful because, as I say, I think there is a prior context of previous policy, which I think was directed more towards assessment of cumulative impact being a barrier, and we now have moved to an approach where it's assessed on an individual project basis rather than a prejudged area. And I think there was a concern genuinely about how, in terms of meeting future targets, that if we accepted cumulative thresholds that were set out in a previous era, that we wouldn't be able to sustain the delivery of onshore wind to deliver the needed targets. So, as I say, the policy slightly moved on because I think it's really dealt with now in the SPP and the spatial framework, and in the paragraph 169 considerations, which are set out there.
Okay, thank you. Mr. Kelly or Mr. Edgar, anything on this point?
I don't think it's hard of anything really to add to that. It's to my mind, really saying to assess each project on its own merit with regard to cumulative impact.
Okay, thank you. Any other comments anyone wants to make on national planning guidance before we move on to the development plan?
Just before you leave this point, Colin is quite right to say that it doesn't set any sort of threshold for cumulative impact, but nor does it help you decide what an appropriate threshold might be. Clearly, there are various kinds of cumulative impact, not only visual and landscape ones. I wonder what the author was trying to do here, except to tell decision makers to use their judgment in different kinds of landscape. Because there's absolutely no guidance or help here about what the extent of cumulative impact might be, either in terms of numbers of turbines or proximity or types of landscape or size of turbines or anything, which puts you, sir, in a slightly unenviable position of having to set your own criteria before you make your decision. At least that's how I read it.
Yes, it's a very unenviable position being a reporter. I'd agree with that.
It's a different question.
But it sounds like there's agreement that there's not too much for me to take from this particular paragraph. Yes, nothing else then on national planning guidance. Then if we can come on to the local development plan then, 2014 it dates from, and so should I consider it in any way out of date? Mr. Bell.
Yes, I deal with the development plan at my section 4.2 in my hearing statement. I do think there are some aspects of it which point to the development plan being out of date. So notwithstanding that the actual adoption date is September 2014, which is post SPP, the current SPP. I think the main points are that the policy, the LDP policy of wind energy, which we're just coming on to, does not contain any balancing provision at all. And when one looks at, I think, pretty much all the wind energy or renewable energy policies now within LDPs throughout Scotland, they all have a capability to consider benefits in the balance when one is coming to a judgment on that particular policy of whether development accords with it or otherwise. And secondly, the reference in the policy to keeping effects to a minimum. I cannot find any reference in national policy or guidance to keeping effects to a minimum level. And again, I can't think of any other LDP policy where there is such an expression to deal with. I think the broader point is that the climate emergency and the net zero position has clearly moved on. National planning policy is about to, and plans such as this one that came into force just as SPP was coming in are clearly at the far end, if you like, of the spectrum of LDPs that are dealing with the national policy imperative and the emergency situation that we're now in. So these are the key points I would say as to why the plan is to some extent out of date.
Mr. Edgar, would you accept any of that?
Our contention is that it remains as a relevant document, that the basic contents of it, the approach is still up to date. It's our defining position in relation to wind energy proposals. I guess it's important to note that the modified proposed replacement local development plan, which has been submitted to ministers for examination, largely repeats and reaffirms the policies in the 2014 plan. There's no substantial change to the wording. So we would consider it is still up to date. Currently, there are unresolved objections to the modified plan in relation to wind energy policy, so we can't rely heavily on that just now. But we consider that the LDP is still up to date. It still meets the requirements of SPP in relation to wind energy, and it's still a relevant document.
Okay, thank you. So should we come on to the policy itself then?
Can I just say one other thing?
Sorry, Mr. Campbell, yes.
Yes, just for your information, the council has approved its modified plan in March of 2020, and it's with ministers for examination. the text of the replacement policies are virtually verbatim for the existing policies. And at the risk of repetition, these are policies which have served South Ayrshire very well, in the sense that it has honoured and respected Scottish Government's wish for widespread deployment of large-scale turbine farms at Kilgallich, for example, and Clauchrie, and elsewhere in the system. So, despite Mr. Bell's comments on the wording of the policy, in reality, you have an instrument which has served both the Council, and surely this is ideal, and Scottish Government very well. And in particular, one might say, this applicant.
Mr. Bell, do you want to come back on any of that before we dive into the detail of the policy?
I would just say that if the council was advancing verbatim the policy that came in 2014, that's clearly not reflecting even the provisions of paragraph 169, that I would reasonably expect it to be amended by the examining reporter. Now, that's not clearly for this inquiry to go into that matter, but if the council's, I think that stance just betrays the council's position that it is not dealing with SPP as it currently stands adequately, or indeed the emerging net zero position. Now, as I say, that will be for a different forum to examine it, but it's perhaps just illustrating where the council is at the moment on this application in terms of the weight that it is giving to certain matters.
Thank you. If we can go on to the detail of the policy then, and a couple of points here. I mean, first of all, the question I state there. So a lot of these elements, for instance, element C, do not have any other significant detrimental effects on the immunity of nearby residents. I mean, as has been said, sometimes there would be a balancing provision in here. And is this policy really saying there shouldn't be any detrimental effects? So that's on, and that applies to B, C, D, E, and F, I think. And secondly, the issue of the word significant, and significant has a particular meaning in EIA reports, and whether I'm expected to apply that definition of significant here, the EIA definition, or is this a normal English use of the word significant? I don't know how this policy has been interpreted in the past. I might start with Mr. Edgar actually on this one. If you could just tell me how you've interpreted those aspects of this policy in the past, please, Mr. Edgar.
Okay, thank you. First of all, dealing with the issue about this sort of lack of a balancing within the policy, I think that is correct, in that you work your way through each of the criteria, and if something was found to be unacceptable against one of those criteria, then it would be contrary to the policy. That doesn't stop, though, at a later stage in the assessment, the assessor from asking the question whether there are other material considerations that would outweigh any negative impact found under criteria A to G. In relation to the term significance, our interpretation of that word is more the common English usage of the word, and not the EIA definition. That's certainly how we've used it.
Okay, thank you. Yes, Mr. Bell, then, do you want to come back on this?
Sorry, yes, thank you. I just think that is not what the policy says. If I appreciate this is a Section 36 case, but if this was a planning application we were dealing with, one could not bring in material considerations when looking at whether a development accords with the policy of the development plan. This takes us back to the basics of the City of Edinburgh case on how to undertake a policy appraisal, is to look at the relevant policies, decide on the objectives of the plan, is the development in accordance with the policies or not, and then, and only then, one moves on to the material considerations. But this policy does not allow for that to be brought in. So if one is following it literally, accepting this is not a Section 25 case where Section 25 is engaged, then that is not how one would apply that policy. I think where I think there is agreement is it's a common sense approach to look at, are the effects acceptable or not, because a distinction has to be drawn between the EIA definition of significant effect or not. And I think Mr. Edgar's helpful in setting out that is the Council's position. And that allows that judgment to be made, notwithstanding that the EIA report does identify some significant effects.
Thank you. Sorry, I'm just catching up with my notes. And probably a similar point then with the policy landscape quality. If I can find that, but it talks about development must conserve skylines and prominent views. And again, that seems quite a black and white approach without much nuance in it. Mr. Edgar, do you have anything a different answer to give in relation to the policy on landscape quality?
I think Mr. Bell maybe misinterpreted something I said there, that I wasn't trying to say that you would bring in material considerations whilst you're assessing something under that policy, under the wind energy policy, or indeed the landscape policy. I was indicating that having concluded an assessment under that policy, and you may say a proposal was found to be contrary to the policy, that does not stop planning authority for still approving a development if there are other material considerations that would outweigh that policy objection, albeit that might be as a departure to the development plan.
Yes, Mr. Bell.
I suppose maybe just put another way, could a commercial scale wind farm be deemed to be consistent with these policies, taking that approach? Would one need to always rely on material considerations and a departure from the development plan?
Mr. Edgar, yes, do you want to answer that directly?
I mean, no, a commercial scale wind farm is capable of passing the tests in that policy, as we haven't objected to other commercial scale wind farms in the area that have been approved as consistent with the policy. It's only where an adverse assessment adverse is of significance that we would say it was contrary to the policy. So it's quite possible to have a wind farm that we would consider does not have an adverse impact on landscape and visual amenity, for example, and it passes all the other policy tests, then it would be consistent with the policy.
So if you say that the wind farms that have been approved in South Ayrshire or been recommended for approval by the council, because they complied with the development plan, they didn't have a significant detrimental visual impact. But I would be surprised if the EIA reports for those wind farms didn't identify some significant visual impacts. But that can perhaps be explained by this difference in the use of the word significant, that in EIA terms, it's a lower bar. And when you're interpreting this policy in planning policy terms, the significant is being used as a higher bar. Would that be a fair way of putting it?
I'm not entirely sure I followed all of that, but again, just to clarify that the word significant is not the EIA definition, so it's a sort of balanced judgment on whether, whilst we might be finding adverse, for example, landscape or visual impacts or noise impacts, it might be that they are of a scale or an extent where we don't consider them to be significant and highly detrimental to the amenity of the area, that we could still approve it even if we had identified a level of adverse impact.
Okay, thank you. Mr. Bell, I think you wanted to come back in.
Yes, just quickly, I think where the difficulty arises is where you have a technology-specific policy, and we've got the benefit of that here with the wind energy policy, to then bring in policies like landscape quality, which from a simple reading that would be, I think, almost impossible to satisfy, maintaining and improving the quality of South Ayrshire landscape and so on, and conserving features, if we take the assumption that the effects will be adverse, but not necessarily unacceptable. And I think in my experience, where you get technology-specific policies, that tends to be viewed as the lead or the dominant policy to which most weight is attributed. And subsidiary policies like the landscape quality one, or even sustainable development, because it deals with matters such as crime, use of public services, public transport, they are of some peripheral relevance where we've got a technology-specific policy. So it's a matter of what weight do we place on those, because they are very difficult, if not impossible, to satisfy.
Thank you. That comes on to my next bullet there then, doesn't it? So, Mr. Edgar, would you agree that when you're looking at wind farm proposals, your first port of call would be this LDP wind energy policy, and that essentially sets out to capture all the main matters that you would be looking at with a wind farm proposal, and to some extent that limits the need for you to look at other policies in the plan?
I'd agree with that. The wind energy policy certainly covers all of the other policy matters that we'd normally consider any development, any other type of development against. So it does capture all the other relevant policy considerations, with one exception, which is the biosphere policy. But other than that, all the other relevant policy considerations are covered under that one policy. Okay, thank you.
Any other points anyone wants to make about the LDP before we move on to the supplementary guidance? Okay, well, let's turn to the supplementary guidance then. And first of all, my first question there is just being clear about where the site sits in terms of picture 3 in the spatial framework. I need to get it up myself first, if you just bear with me. Yeah, so Mr. Edgar, yeah, just to clarify where you think the site sits in terms of the supplementary guidance and the spatial framework.
I think we've touched on this already earlier this morning. We consider within one of these red splodges, I'll call them, within a category 2 area of significant protection, sorry. Yeah. And I see on page 7 where there's all the contributory layers that feed into that. Is it here? Yeah, picture 2.
Yes, I thought there was a reference somewhere. It's not there. Is there a reference somewhere in here to this being, particularly the peat, being an interim position subject to further study?
Yeah, I believe that's correct. It's the peat that moves it into category 2.
But is it correct that there's a reference somewhere in this document to? Yes, in the previous page, on page 8, where there's the table. And I'm having to turn my head sideways to read it, but in the middle column of the table where it says other nationally important mapped environmental interests, and then you come down and there's a bit in italics that says the government have recently concluded a consultation on the extent of land within Scotland as a carbon-rich soil. It is recognised that pending the outcome of this consultation, the area shown for this constraint may change. So that seems to be saying that the carbon area shown in the map on the next page is subject to change. Is that correct?
I have to be honest, I don't know the answer to that, sir.
Okay. Okay, but there's agreement that at the moment, in terms of the map on page 10, it seems to be quite large parts of the area would fall within an area of significant protection. Though we've discussed that the further study of peat would allow my detailed interrogation of that. Mr. Bell, do you agree with that?
Yes, I think that's fair. The only point I would make is that the site boundary covers more than just the red areas. It covers some of the green,
Yeah.
and it clearly goes into Dumfries and Galloway, partly for the access as well.
Yeah, good point. And then my next question there was about Appendix 2 and an area north of Bar Hill with scope to accommodate further large turbines. Mr. Edgar, is your understanding that that reference can be taken to apply to the appeal site?
Yes, and that's a fair comment.
And presumably Mr. Bell would agree with that.
So yes, I was just going to say I do, and I think there is it's important to cross-reference that back also to Mr. Welsh's evidence for the applicant, where with regard to character area 18C and what Mr. Welsh talked about in terms of the position of the development relative to the settled valleys to the north and the wildland area to the south, where it was in his view, sort of optimized, if you like, in terms of that area. So that planning foundation, if you like, of the position in that guidance document to the landscape evidence, that link is important.
Okay, thank you. Now, I think I have one more question on Appendix 2. I can just come back down to that, which talks about the turbine typology. And again, going back to that capacity that was identified north of Bar Hill for large turbines. But then here we see in Appendix 2 that large turbines are over 70 meters in height. And obviously we're contemplating turbines here of 200 meters in height, which is getting over 3 times as high. So how much are such turbines of such a different scale that I should perhaps not give too much weight to a statement that says that there's capacity for turbines of over 70 metres. Mr. Edgar, I don't know if you've got a view on that.
Yeah. It's important to note that the Appendix 2 of the guidance provides a summary of the main findings of the South Ayrshire Wind Farm capacity study of 2013. The 2013 study was replaced by the 2018 study, and this updated that original finding. And as you would have heard in Ms. Anderson's evidence, that included assessment of turbines over 130 metres high. And essentially the same findings are found within this area. There's still considered to be some scope for these large, very large turbine typology, with the caveats though regarding the Merrick Wildland area, and the impacts on the Dusk Valley and Stincher Valley. So I believe that the guidance is still up to date. It has taken account of those large turbine technologies, and that there's still possibility of a scheme in that area that could be accommodated.
Okay, thank you. And Mr. Bell, again, I assume you agree with that?
Yes, I mean that is very fair, and I think as Mr. Welsh, put it in his evidence, the study is pointing to, if there are to be large turbines in South Ayrshire, this is the location for it. Effectively, the guidance points to this area.
Okay, thank you. Any further comments from anybody on the supplementary guidance? And then I also note the dark sky supplementary guidance here. I haven't got any particular questions about this one, but does anybody have anything further to say on the dark sky guidance? Happy to move on. Yes, Mr. Edgar.
Yeah, just to say that our report to the panel regrettably failed to mention the dark sky supplementary guidance, but what I would state is that it is a material planning consideration that you would want to have regard to and come to your decision on this.
Yeah. Thank you. Okay, if there's nothing else on the development plan, then can we just, before lunch, quickly touch on other local policy? I think we've covered proposed LDP2 in your earlier answers, but is there anything further either of you wish to say on the content and prospects for LDP2?
I think there's agreement that it's limited material status at the moment. I would wait. Yeah.
Yeah, I agree with that.
Yeah.
Limited rate. And then finally, the wind capacity study 2018. So this isn't, I'm correct in thinking this isn't supplementary guidance itself. So the views please on its status and the weight I should be giving to it and whether it is still up to date. Mr. Bell.
I think the view is generally it's reasonably up to date. I think Mr. Edgar just confirmed that. It is a strategic level starting point. I think that's fair to recognise, and that more weight should be placed on a site-specific assessment. And I think it's important to recognise when the two come together, when the site appraisal through the EIA report and LVIA is consistent and with the findings of the capacity study, that is when there's greater confidence in a position that a development is the right development in the right place. And I think that's where the applicant arrives at in this case.
Mr. Edgar and Mr. Campbell, would you agree with that? Mr. Edgar?
I agree that first of all that it's 2018 it's reasonably up to date. I think it can be relied on. As I said in the earlier answer, I also considered the larger turbine typologies that we're now seeing. So I think it remains valid in that respect. And as Mr. Bell correctly says, it's a strategic document which is then followed by a detailed site-specific assessment of any particular proposal. That's the correct way to use it.
Thank you.
I just want to repeat that its predecessor, of course, was by the same author, as she told you. And it has proved a successful grounding for the consents that have been granted already. So, as a strategic tool, you can have confidence in it.
Okay, thank you. Now, if there's nothing else there, I think that's an appropriate place to stop for lunch. I think I said to Ms. McDade that we wouldn't start again before 1:30. So that gives us just over an hour for lunch. If people are happy with that, then we'll break there and we'll come back at 1:30 and we'll go back to item 2 of the agenda and take it from there. So I'll see you at 1:30, please.
Thank you.
Thank you.
I'll just check everybody that's just joined can hear and see me. Is that okay? Thank you. Thank you. Ms. McDade, can you hear and see me okay? Yep, thank you.
Well, welcome back everybody from your lunch. I'm going to try with my video on again to start with. Is it working at the moment? Can people hear me and see me? Yeah. Let me know if there's any difficulty with my sound going. Then let me know, and I'll just turn the video off again. Ms. McDade, I see you've joined us. Welcome. Can I make sure your sound's working?
Yes, can you hear me?
Yes, you're a little bit quiet, but
Somebody else
let
is.
me know, and I'll just turn the video off again.
Okay.
Ms. McDade, I see you've joined us.
You turn up your microphone output.
Make sure your sound's working. Yes, you're a little bit quiet, but okay. Was there some delay then? I think with my.
Considerable delay.
I'll go with the video off again, just to make sure we don't have any problems. Right, welcome, Ms. McDade. We've dealt with the planning policy issues this morning, which I think you had less interest in. Is that correct? I'll go with the video off again. Make sure we don't have any problems. Right, welcome, Dave. We've dealt with the planning policy issues this morning, which I think you've had less interest in. Is that correct?
I couldn't attend this morning, yes.
I was hearing my voice back there about 20 seconds after I spoke, but hopefully we're live again now.
I'll turn my video off. I couldn't attend this morning, yes.
Right, okay. Yes, I can hear you fine anyway. I was hearing my voice back there about 20 seconds after I spoke, but hopefully we're live again now.
Well, no. I'll turn my video off. That's.
Right, okay. Are other people hearing me twice?
No, just once.
Right, okay.
I think the problem is with Ms. McDade, if I may say so. It's obvious that her microphone output needs to be turned up. And now it needs to be turned on because it's not working at all.
Yes, yeah, you're on mute now, Ms. McDade. But, I can't hear you, Ms. McDade, so I think you're on mute. You're on mute now, Ms. McDade.
I'm not on mute now. It will come on in 20 seconds.
Yes, I heard you say that now. So I think you're on mute. I'm still getting this delay.
Not on mute now. I said that 20 seconds. Come on in 20 seconds.
Yes, I heard you say that now.
Yeah, 20 seconds ago. I'm not on mute.
Graham, do you know what's happening here?
I said that 20 seconds. Come on in 20 seconds.
Not really, no. I think there must be a delay somewhere with Miss McDade's connection. That's why we're getting the double feed somewhere.
Not on mute.
I wonder, Ms. McDade, or Graham, do you think it would help if Ms. McDade logged out and logged back in again?
That could be a possibility, yeah. If you want to log out and log back into the meeting, we'll see if that helps. If not, shall we?
I think we'll.
If not, the other problem might be she might have to switch her video off and keep herself muted until she needs to speak, because I think there's an echo from her end somewhere, and that's where we're getting the delay.
Yes. Well, she seems to have gone now, so we'll just wait for a few minutes to see if she comes back, if it's resolved itself.
So
yes, Dr. Gordon.
While we're waiting, while I have a small number of points that could be made, they can equally well be made in closing submissions. So I would propose to do as I did this morning, turn off my mic, turn off my video, but still be present in the room should you wish to call out my name.
That's fine by me. And if you want to make yourself known to me at any stage, then
I'll
just
so
put your video on and give me a wave.
I shall do that. Thank you, sir.
Thank you.
Okay, can you hear me?
Perfect.
Yes, I can. Can you hear me?
Yes, I can.
Right, that sounds better now. Good. Excellent. Now, as I was saying, we've dealt with some planning policy matters this morning, and I think I did hear you say that your main interest was in the energy policy items. So we're now going to go back to item 2 on the agenda, which is the legal framework. And as I said in an email in response to a question from Mr. Campbell, I'm not expecting detailed legal submissions at this stage. And if people do want to make them, they can put them in their closing submissions. So it's really just an overview of parties' positions, really. But the first question I've asked there is about section 3A of the Electricity Act, which I suppose I'm more familiar with people quoting Schedule 9, paragraph 3(1) at me. But Ms. McDade, I think you raised section 3A. Do you want to briefly tell me what the pertinent points that I should be looking at there are, please?
Yeah, sure. I won't read it all. It's in my submission, but in 3A it does say the principal objective of the Secretary of State, or in this case the ministers, is to protect the interests of existing and future consumers in relation to electricity conveyed by distribution systems or transmission systems. And it then goes on to say what those interests are, and they include security of supply of electricity, whether there is any other manner, whether or not it would promote competition, which would better serve those interests. And also there is reference to individuals with low incomes and individuals residing in rural areas, and to secure a diverse and viable long-term energy supply, having regard to the effect on the environment. So, you know, that makes it clear that those things are key points to be taken into account. And, you know, I am astonished that the applicant has not referred to it at all in their statement.
So is your suggestion that when that section is talking about, for instance, people living in rural areas, that's meant to be a reference to the potential impact of, like the visual and landscape impact on those people, rather than the impact of, maintaining the same price of electricity for people in rural areas. And it's not just limited to energy markets. You think that's a wider reference to the whole?
I think it's a reference to making the right decisions, but because it also includes individuals who are disabled or chronically sick and individuals of pensionable age. So I take it to be a reference partly to what would cost. It then mentions individuals with low income, but individuals residing in rural areas, I take that to be interpreted as meaning that they are not disadvantaged by the decision. I mean, I'm not a lawyer, and John has asked whether this was going to be a legal discussion, and I'm not a lawyer. I'm just bringing to the table the fact that 3A says the principal objective of the Secretary of State is to protect the interests of existing and future consumers, and then goes those specific interests. So I think that's clear. It's not just about the environmental aspects under 9, and I am surprised there is nothing from the applicant on that.
Okay, I'll come to Mr. Campbell next because he had his hand up. Mr. Campbell.
So I'm sorry to throw cold water over this submission by Ms. McDade, and I should have warned her about it, but Section 3D of the Act disapplies the functions of the Secretary of State under Section 36 from the application of Section 3A. So Section 3A doesn't apply to this application.
Well, I'm not a lawyer, and I did read the section at the time, and yes, advance notice would have been appreciated, John. And obviously that's what the applicant is about to say, and I leave it to the reporter to look into that himself. Since I'm
not trying to make any special point here, but unfortunately, sometimes when you read a statute, you have to read the whole thing because this section is disapplied from the consenting section, which is Section 36. I think Mr. Innes would probably agree with that.
Sure he will.
Well, let's hear from him, Mr. Innes.
Yes, thank you, sir. Just to set the context of subparagraph 3A of the Electricity Act is principal objectives and general duties of the Secretary of State and the authority. And what they mean by the authority is the Gas and Electricity Markets Authority. And we'll probably come on to mention that briefly later in a couple of matters. But insofar as how that operates, it operates through a secretariat called Ofgem. So when you hear the word Ofgem, that's effectively the Secretariat of the Gas and Electricity Markets Authority. Effectively, this section sets out the thought processes and those interests which in setting up the regulatory systems that are critical to the implementation of the Electricity Act, that these are broad principles which the Secretary of State and the Gas and Energy Markets Authority have to have regard to. And insofar as those are set effectively to set the framework for the subsequent regulatory context. Now, we are going to talk about this later in generation, but there's a whole section of the electricity industry which is heavily regulated by Ofgem, and in that context, this sets the framework for how they should go about setting up a regulatory system, and it's taking all those interests into account that the system is set in play. And one of the issues, and I'm just going to say it, is that effectively, and you'll see from the white paper some of the diverse interests that are taken into account in energy policy, but consumer interest is squarely within the remit of Ofgem and the consideration of these matters. And that's all set out in the regulatory processes and conditions. So in terms of this particular aspect, because of Section 3(d) of the Electricity Act, Parliament's expressly stated that this does not apply in relation to the functions of the Secretary of State in Section 36 and Section 37 applications, because they're separate, they're development consent applications. These broad principles are applicable to the broader context of the regulatory framework provided by the Act. And as I say, we're going to touch on it very later on, probably when we touch on grid, but it's not relevant to the determination of this application. And equally, it's actually not a duty on the Scottish ministers. It's actually a UK reserve matter, and it's a duty on the Secretary of State of business, enterprise and industry phase.
Thank you, Mr. Innes. I think that possibly wraps that one up, Ms. McDade, unless you want to say anything further on that.
Well, no, I would refer you to Section 3B and see if you agree with those interpretations.
Okay, yes, I'll have another look myself. Thank you. Coming on to the next question then about has the applicant met its duties under Schedule 9, paragraph 3.1? And I suppose I'm particularly interested here in doing what they reasonably can to mitigate any effect and what that means. But Mr. Innes, perhaps you'd like to kick us off on this bullet point, please.
The applicants hold a generation licence, and I think, as we've acknowledged throughout this process, have been aware of the duties in developing Section 36 consents that arise from that. In relation to subparagraph 3.1 of Schedule 9, the first matter is that the applicant must have regard to the desirability of a series of measures and effectively preserving natural beauty, conserving various aspects, and then protecting sites. And each has a slightly different phrase that's used to direct it. So in terms of natural beauty, it's preserving it. In terms of flora, fauna, and geography, it's conserving them. And finally, it's protecting physically sites of buildings and objects of architectural, historical, or archaeological interest. So in respect of each of those three matters, these are all components of matters which we have fully addressed, both in the design of the scheme and in the environmental impact assessment that accompanied the application. And I think it's very important that these are matters to have regard to. These are factors we've got to take into account, but that's the extent of it. We've got to take into account, we demonstrate through our design and our iterative design process how we've gone about balancing the various interests and how the final design's been achieved. And you'll see there very clear that landscape and visual matters have been very carefully considered in the formulation and design of the project. And equally, the underlying habitat has been subject to very substantial review. And in particular, we heard this morning about the over 1,900 peat probes. That's all part of conserving flora and fauna. And you'll understand that that played a very key part in the final design of the processes. And we have a whole chapter on cultural heritage, which has assessed the potential impact on any buildings, objects of historic and archaeological interest. So those matters have all been addressed. And in terms of mitigation, in my submission, you can mitigate in more than one sense. But one of the first ways you mitigate is through good design. And you'll see from the design process set out in the environmental statement how much effort goes into the design at that critical phase of the project. And that's where we largely mitigate to what we reasonably can, is through that design process. And insofar as that we have effects that we are unable to mitigate, we've also gone on to provide mitigation through proactive habitat management. So in the context of there were certain effects that we were having on peatlands, and what we were able to do was identify an area close by that we were able to undertake a substantial habitat management plan, where rather than just leaving matters as a neutrality, we'd seek to achieve real positive gains in terms of creating a really high quality habitat that more than offset the impact of the scheme. And that's what the applicants have got a particular expertise of. They've got a lot of experience in dealing with development on peatlands, and they've also got probably as much experience as anyone in dealing with habitat management plans that respond to those impacts and seek to achieve a positive outcome in those respects. So in my submission, that's all been very clearly demonstrated through the environmental statement and through the actions which we've taken, and which will ultimately also be delivered through the requirements and conditions in terms which we'll discuss at a separate session. I also want to highlight there is a separate and distinct obligation over and above that is under subparagraph 3, which deals with avoiding so far as possible injuries to fisheries or stocks of fish and waters. And again, the ecology chapter has very carefully evaluated these matters and has sought to ensure by again separating infrastructure from watercourses, and also suggesting very established methodologies for carrying out mitigation as to how the project would be undertaken to ensure that that particular duty would also be met in terms of the implementation of the project. So as I say, there's very careful consideration given at all stages of the development of the project for these issues. And in each stage, we're finding both mitigation through design, trying to avoid, providing positives, and also recognizing that the way in which it's constructed could have impacts, and how that can be properly managed through effective management regimes through the conditions. So taken as the entirety, in my submission, it's very clear that we, the applicants, have fully complied with the duties that have been set out in Schedule 9. And I think it's very important to understand that it's in respect to this scheme, not some alternative scheme. It's this scheme as put forward that we have to consider. This is in some ways much narrower than an environmental impact assessment requirements, and it's very specific in its requirements.
Thank you very much. Mr. Campbell, do you agree the applicant's met its duties under this section?
No, sir, with respect, I don't. Mr. Innes is quite correct when he quotes from Schedule 9, paragraph 3.1. It says that all that the applicant have to do is to have regard to preserving, conserving and protection. Actually, what it says is have regard to the desirability of preserving, conserving and protection. And the obligation is a little wider, if I may say so, than simply looking at the matter having regard to it. Now, you start with the proposition that the turbines at 200 meters are suitable for this location, and then you iterate the design, or they have iterated the design, so as to, as they would say, fit the location and have regard to the desirability of mitigation. But Mr. Innes gives the matter away when he says quite clearly that the best mitigation is achieved through good design. You have in front of you landscape and visual evidence, which shows, in my submission, that the mitigation of this very large development in this location does not achieve any mitigation, because it remains obvious, it remains visible from a great distance, and it has an impact on not only 5 houses, but also the Disk Valley and the Stincher Valley and the areas to the north, all as spoken to by Ms. Anderson. I don't want to run through the landscape evidence again. I recognize that there's a habitat management plan. I recognize, of course, that SPR has experience in carrying those out and designing them. And I've no doubt that if that is done, the habitat will be beneficially affected. But if you start from the beginning and say, have I had regard to the desirability of preservation, conservation and protection in this location for this design, then they may have considered it, but they cannot conclude that they have preserved, conserved or protected any part of this site for the reasons given by the specialist witnesses. So I will argue in closing that the duties in Schedule 9 have not been complied with.
Thank you. Before coming to Ms. McDade, Mr. Innes, do you have any response to that? Or
I'll probably wait to hear from Ms. McDade and then probably do a wrap up, probably the quickest.
Okay, Ms. McDade, do you have any comments on this section 9?
I mean, I refer to the evidence given by my colleagues in the landscape and visual part of the inquiry. I have not assessed this myself, so I don't have further comment than to refer back to that evidence.
Okay, thank you. Back to you then, Mr. Innes.
I'll be very brief. In terms of what Mr. Campbell said, I fundamentally disagree with his interpretation of the way in which Schedule 9 should be applied. It's perfectly permissible to have designed a scheme that meets Schedule 9 but is unacceptable. They're two separate issues. One is we've got to have had regard to these the desirability of having regard to these. And we did do a qualitative evaluation of all these assets in terms of how they sit and how important they were, and in terms of understanding which aspects were going to drive design. That's exactly how you have regard to the desirability, is understanding the importance of the different aspects that you're dealing with and attributing appropriate weight to those. But the fundamental point is this is not about a question of acceptability. This is a question of process. In the scheme before you, have the applicants had regard to these matters, and have they done what they reasonably can? That is what effectively government or Parliament is required. And really it's about making sure that the privatised electricity companies have due regard to environmental matters in terms of formulating their proposals. It's not a test of acceptability. It's a driver to make sure these things are properly considered. And in our closing submissions, we'll make reference to, there's been a number of court cases on relation to the Electricity Act, and that's also included discussion of Schedule 9 and some of its history. But that's the background. There was duties previously on environmental duties on electricity boards, and they were essentially just transferred over to apply to the newly privatised entities to ensure that they had proper regard to environmental matters whilst formulating proposals. And that's the context and how it should be read and interpreted. It's not about whether you pass or fail a subsequent test about whether or not consent should be granted. That's a very separate issue. It's this scheme, and I don't think what I'm hearing is Mr. Campbell suggesting it's about looking at the whole thing and saying it, but it's about, have we done it with this scheme? Could you have moved turbines slightly differently? And the answer is no. We've had very careful thought was given to the design of this scheme, and I'm quite after rest there, but we do have a difference of interpretation that no doubt will be reflected in our respective submissions at the end of this process.
Thank you. I understand your two positions. That's fine. I'll move on to the third bullet point there about the status of the development plan. I think this is, well, at the moment it's clear in my mind, but I'll be back with Mr. Bell again just to give us a brief, his brief understanding of the status of the development plan here.
Yes, thank you, sir. In my hearing statement at paragraph 1.8.2, I deal with this point, where I set out that within the Electricity Act there is no prescribed consideration at all of the development plan, and it's fairly common. It is common ground, I think, with the council that Section 25 does not apply. Therefore, there's no primacy of the development plan. It is, of course, an important consideration that is accepted, but Section 25 of the 97 Act does not apply. There's no primacy, as would be the case as with a conventional planning application. And there's fairly settled case law on that now, which is also before the inquiry.
Mr. Campbell, would you concur with that?
Yes, indeed. The case of William Grant, which I remember with no affection at all, makes it absolutely clear that the Section 36 provisions are, as the judge called them, an independent code. Now, this ties back to Mr. Innes's previous submissions. He's twice said it is this scheme in this location, and this is not about acceptability. So if we didn't have a development plan to refer to, the only test of acceptability would be in Section 36. But we do, because, as we know, Section 57 of the Town and Country Planning Act imports a deemed planning permission if a consent is granted under Section 36. And that brings into play the development plan, not as the prime indicator of acceptability, but as a significant material consideration. And I agree with Mr. Bell about that. Section 25 does not apply. We're absolutely at one on that. But the development plan and its considerations are what, along with Section 36, are what determine acceptability overall. And Mr. Innes would divide the two and say one is a process for simply having regard to all the constituent components of the site, looking at them, weighing them up, redesigning the scheme, and eventually coming forward with a proposal. I say that ministers have to look at this in the round. They look at Section 36, they see if it's been complied with for this scheme in this location, as Mr. Innes has said, and then when considering acceptability, they'll look at that, and they'll also look at what the local authority's development plan says about this type of development. It is, if you like, a holistic approach, looking at all the regulation for this type of development in this location. It is not a desiccated compartment by compartment approach so that you tick a box and move on, tick another box and move on. Look at them in the round. The proper planning judgment, which, sir, you inevitably have to come to, is whether or not, looking at all of these considerations, that the applicant has survived the policy, survived is the wrong word, has passed the policy tests which are set for him both by Section 36 and by the development plan.
Thank you. Ms. McDade, do you have any contribution on this item? No. Then, does the applicant want to come back on that, or can we move on to item 3?
Comments about that. I do want to come back on one point, 2 points actually. The first is that Schedule 9 to the Electricity Act also applies to electricity companies, certain electricity companies doing things under permitted development where there's absolutely no consent required at all. So in terms of looking at how this applies, it's not about acceptability. In my submission, it's clearly about a process to be gone through in terms of Schedule 9. In terms of other matters, in terms of the environmental impact assessment, there's absolute requirements on the Scottish ministers to reach conclusions in relation to certain matters. Again, those conclusions have nothing to do with whether or not this project should be consented or not. There are requirements of the process to ensure that environmental matters have been properly taken into account. And where we probably in part agree, I part agree with Mr. Campbell, is that what this decision making ultimately comes down to do is to bring everything into the decision making, whether it's the development plan, energy policy, other statements of policy and guidance. They all come into the melting pot for the final decision making, to which there isn't a requirement to decide matters in one way or another having regard to any particular factors. What you do need to do, though, is ensure that all matters are properly identified, and thereafter it's up to the ministers to decide what weight to attach to various aspects of policy in coming to a conclusion as to acceptability. So we're agreed in the sense that everything comes in at the stage of decision making, but ultimately where that bears is up to the decision maker as to which aspects they choose to attribute weight to in the ultimate decision making. And that, I think, as we see, almost invariably ends up balancing the positives against the negatives and reaching an overall balance and conclusion as to the acceptability of the scheme. So I don't think we're that far apart. It's just how we get there, maybe slightly different between Mr. Campbell and myself, and no doubt will become clearer in our respective closing submissions.
Okay, well, it's relatively clear to me already, so that's a good start. If we can move on then to item 3 and climate change targets. Perhaps again, starting with Mr. Bell, just to clearly set out for me, please, what the current applicable targets are for greenhouse gas reduction and the progress made to date in meeting those targets. Over to you, Mr. Bell.
Thank you. Yeah, thank you. In terms of greenhouse gas reduction targets, my hearing statement, Appendix 1, deals with the climate change emissions reductions targets, Scotland Act 2019, which amended the Climate Change Scotland Act 2009. And if we remember back to that, and it's reflected in SPP, NPF3, the target had been an 80% reduction by 2050. The 2019 Act received royal assent in October 2019, and its commencement regulations came into force in March last year. And in my hearing statement, I have set out a table which is replicated from a government website, which sets out the progress against those targets for each year running up until 2045 for net zero. So that the extract from the website is before the inquiry as document APP 6.15, and my table provides a quick ready reckoner as to where we are on that. So in my table, for ease of reference, it's page 55 of my hearing statement. We can see that for this year, the target is 57.9% reduction. Last year, it was 56%. That was an interim target year. Now, the latest information we have is set out in the annual report that the Scottish Government produces on greenhouse gas reduction statistics, and that is before the inquiry as APP 6.13, and that gives the figures for 2018. So in the table, you can see I've put in the actual reduction for that year of 50%, and that was against the target that year of 54%. So the target was not achieved for the first year, and you can see the profile for each year set out with the interim stages up to 2045. And the key point is that the law changed in 2019, bringing the targets into force in March last year, and the fundamental difference to what is in NPF3 and SPP, as we touched on earlier. So those are the applicable targets. That is the position as to where we are at the moment on them. And I suppose it also demonstrates the point that planning policy is catching up with this legal position on net zero, as we discussed earlier this morning.
Mr. Campbell, do you agree with all of that? I think you're on mute, Mr. Campbell.
Some of it, yes. Mr. Bell's analysis of the requirements of the Climate Change Act and the Emissions Reduction Act are very helpful. But I draw your attention in APP 6.13 to the graphic at section B, which is on electronic page 11.
If you want me to look it up, just bear with me a moment.
Yes, please. It's called chart B1.
Which page again? Sorry.
Electronic page 11.
Thank you.
Sorry, and actual page 11 as well. I just want to draw just want to draw your attention to the place of energy supply in that table. It's not top, it's not second, it's not third, it's fourth. And industrial processes are well below that. So we can see from the following table, also called table B1, that the energy supply total of 6.8 is then divided up by the
Oh dear, I think we've lost Mr. Campbell. We'll just wait for a minute and see if he comes back.
I lost you there for a moment.
Yes, you're back again, Mr. Campbell. You're taking us to table B1. That's where I think we lost you.
Yes, I was taking you to table B1 just to show you the place of energy supply emissions in the spectrum of causation, if you like, the spectrum of the causes of harmful emissions. If you work through this document, you can see the changes in emissions over the period and the sources, or the government statement about the sources of these emissions. Now, we're concerned here with a wind farm, and what we are not seeing is any relationship between the potential of this wind farm, this proposal, to the reduction of carbon emissions anywhere. Not in Ayrshire, not in Scotland, not in Western Europe, not in the world. All we know is that there will be renewable generation when the wind blows, and that it's likely to be of the order of between 25 and 30% of installed capacity. How does that relate to the reduction in harmful emissions? I'll leave the question for you, sir.
Mr. Bell.
Yes, I think this table helpfully illustrates that the metric tonnage of carbon dioxide emissions is relatively low for energy supply. That is because over the last 20 years, there's been a great success story in Scotland of taking fossil fuel generation off the overall generation platform, with the likes of Von Gannett and Cockenzie coming off. There's still Peterhead with gas. And that is a position that reflects the UK profile overall, with pretty much all coal generation about to come offline. And it also demonstrates that the harder sectors are still there. So heat, building, space heating and cooling, transport and business use are the persistent offenders that have been very difficult for renewable generation to get through to. But we know that for net zero, there needs to be massive electrification to allow a greater and full penetration of renewable supply to those sectors. And we will come on with the white, when we get to the white paper, to show what the government forecasts are on that. So I think the answer to Mr. Campbell's question will be, we will see the relevance of large-scale renewable generators and how they're anticipated to play an important contribution in the government policy picture when we get to the white paper and also the 6th carbon budget document. Thank you.
Thank you. Ms. McVeigh, did you have any comments on this section, item 3?
I mean, I agree with Mr. Campbell's point about how low this does come down, and you know, that's just been acknowledged by the applicant, saying how difficult it is to do the other sections. However, I would want to point out that these are greenhouse gas targets, and they are not all achieved by increasing energy, but in fact by greenhouse gas retention. In peatlands, Scotland's peatlands are amongst the best in Europe, and forestry. And Mr. Innes referred earlier on to a habitat management plan, which would restore these and indeed enhance what's already there. But you can't restore living peat, and I'm sure that point has been made at other parts of inquiry. Once you dig it up, it's not doing the same job that it does, and it's an important retainer of greenhouse gases. So it's not a simple equation, and it's certainly not simple to say that onshore wind is then the must-be answer.
Good, thank you. Any further points on item 3 before we move on? Then if we come on to item 4, renewable energy policy, range of documents here. I'm just wondering how we package this up. Perhaps if I come to you first, Mr. Bell, to look at perhaps we'll put the declaration of the climate emergency. That seems to be a separate item we can put to one side for now, and the statements about environmental protection. So if you could address the first 3 bullets, please, Mr. Bell, at this stage.
Thank you. It may be Mr. Innes comes in at 1 or 2 points. The first matter is the energy white paper, and I referenced that at my paragraph 7.3.47, where I provide a summary of some key points. Firstly, it's a policy document that applies to the whole of the UK, with energy not being a devolved matter. And it sets out a number of matters which we've been discussing already. The net zero target for the UK for 2050. It sets out a clear forecast of the expected electricity demand picture for 2050, and that is powerfully illustrated on figure 7.3 in my hearing statement. Now, I've replicated the graph that's in the white paper, and you can see in that the supply or the electricity demand is expected to grow very considerably by 2050, and the other sources shrink. And that is quite dramatic in that graph. So that is the point that I was linking to what I was saying earlier about the electrification.
Is this figure 7.2?
Sorry?
Figure 7.2 of your hearing statement.
Sorry, figure 7.3 on page 51. It's the bar chart, the horizontal bar chart.
Okay, I see. So the lower of the 2 bars refers to 2050.
Yes. So you can see that the proportion of electricity compared to 2019 is about 3 times bigger, almost, just by visually comparing it. It's a dramatic difference. And that is the recognition that by 2050 for net zero, there needs to be massive electrification in the sectors that we looked at on the vertical bar chart earlier with Mr. Campbell, in terms of the heat, the transport, and those sectors that have proved to be very difficult to decarbonise so far. The other aspect of the white paper that's important is the reference to the need for a green recovery, and there is also reference to different technologies, and it recognises that onshore wind will be a key building block in getting to net zero. And of course, offshore wind gets considerable reference as well, and we'll come on to that. But those are, if you like, the headline points that I would say are relevant from the white paper.
Okay,
well, I'm just going to 2 further points I just wanted to make. The first is that I think the white paper is a very useful document in understanding the scale and radical nature of change which requires to be undertaken to achieve the future climate change objectives. And it covers energy as a whole, and therefore it's helpful in putting these things in its broadest context. And having been involved in advising on energy policy related matters for the past 25 years, I think this is the most profound change in UK energy policy in terms of its ambition and its clarity as to where the change needs to occur. We have, in UK terms, probably been less specific about where and how we were going to change in renewables terms. This changes that picture and really catches up with a lot of the Scottish policy development. And if you go back to how this all fits together, in Scotland back in 2017, 2016, we were thinking, what's this going to look like? And you see the energy strategy, which isn't definitive as to where it's going, but identifies some of these challenges. And again, this white paper really is wrestling with some of that challenge. And I think what I would say is if you the key points in relation to what's relevant here is page 38, which is the opening gambit of the whole section on power and the future of power. And it sets out there the goal. Electricity is a key enabler for the transition away from fossil fuels and decarbonising the economy cost effectively by 2050. It then goes on to say that under the first bullet point, we will accelerate the deployment of clean electricity generation through the 2020s. And that's the UK policy now, is it's electricity generation is the power sector that's going to drive to the objectives. But also it has to be done cost effectively. And I think there's one other point I want to just take out of the white paper at this stage. And that is, it would be fair to say that English policy towards onshore wind has been challenging. And part of that challenge has also had consequences for the market support, which has been offered to the technology since 2015. Prior to 2015, onshore wind was able to gain support from government schemes, which provided payments to support the transition to renewable energy. In terms of how that approach has changed, is in terms of offshore wind, we started going through competitive auctions to bid in to be successfully supported. And the key driver there was to try and encourage the large offshore supply chains to become more competitive and drive prices down. So the concept of moving away from direct subsidy to CFD auction has been a key development. And up until recently, onshore wind was not eligible to bid into those CFD auctions. And effectively, there's been no market support for onshore wind since 2015. And how that fits with Scottish policies, if you actually read the onshore wind policy statement from 2017, a lot of that is dealing with the issues about how we're going to maintain the deliverability of onshore wind in circumstances where there is the market support for the sector has been removed overnight. So that's the context for that 2017 onshore wind plan statement. Now, what's changed? Well, the UK government, this UK government has taken a different attitude to previous UK governments and has chosen now to make onshore wind potentially eligible for future CFD rounds. And that's reflected on page 45 of the white paper, where we say the next auction in late 2021 will be open to onshore wind, solar and other established technologies as well as offshore. So what we're seeing is an opening up of that market for onshore being able to get a support from UK government's financial mechanisms going forward. The previous exception had been the Scottish Government negotiated that onshore wind schemes on the islands in the last CFD round could bid into the auction process, and a number were successful through that process and bidding in. So I think that's an important context from the white paper for onshore wind. And furthermore, within that context, at paragraph 45, it says that onshore wind and solar will be a key building blocks for the future generation mix, along with offshore wind. Now, the white paper is very, very supportive of offshore wind and is looking to achieve a very significant growth in that sector to achieve targets in 2030. But even with that objective, it clearly identifies the importance of the ongoing delivery of other technologies alongside the offshore wind piece. And I think that's an important change and one which obviously the Scottish Government have lobbied quite hard for to get onshore wind back into the CFD auction process. And we now have it with commitments made in the white paper by the UK government to facilitate that. And I think really the best way of explaining is England still has a very restrictive planning regime for onshore wind schemes in England. Wales have gone for a very supportive scheme for onshore wind recently with policy changes supportive, and in Scotland we obviously will come to look at our own policy. But what I think it recognises is different parts of the country will play different parts in the energy mix, and that's being respected by the UK government, having had discussions with the various administrations around that. And I think that's an important context for onshore wind, and that's why I wanted to just take a bit of time to set that out. Thank you.
Thank you. That's all on our first bullet. I think we'll deal with this now and do around the houses and start with Mr. Campbell, please. Any comments on the Energy White Paper and what you've heard?
Well, the Energy White Paper is what it is, and we can all read it. Of course, it takes a little while for these policy aspirations to be translated into legislation, but assuming that happens, I just want to pick up one point in Mr. Innes's last contribution, which is looking at the different nations of the UK as, if the way he put it, was performing slightly different functions. And he instanced the England first and Wales, and then he just said, well, Scotland has its own policies. Now, all of these components of the United Kingdom have their own contributions to make in different ways. Does the white paper change this? Only insofar as the onshore development is brought back into the CFD system, which will, of course, encourage development. One might ask, sitting here and listening to my own friend, Mr. Innes and Mr. Bell, what is the point of having an examination of this kind into a wind farm proposal? If things were pointing all in the one direction, as both of them say they are, then there could be few, if any, reasonable restraints on large-scale wind farm development. And yet here we are, looking at the minutiae of this particular development. Does the white paper change that? I think that's a matter for closing submissions, and not today. I don't think it does, though.
Okay, thank you, Mr. Campbell. Ms. McDade, anything on the white paper?
Yes, I mean, I think Mr. Campbell makes a point. We're presumably here for a purpose, and everything can't be passed in the basis that's been put forward by the applicant. However, I would take issue with a few points from the applicant and what they've just said, what Mr. Innes has just said. And the UK white paper does mention onshore wind, of course it does, and no one's disputing that there will be some more onshore wind. However, if you look at their 10 priorities, they start with offshore wind, go through hydrogen, nuclear, electric vehicles, more marine, carbon capture. So the onshore wind is not in those priorities, and they haven't shifted their priorities significantly in respect of that. Yes, there's a lot, and this is where, in terms of Mr. Bell's evidence in his paper, very often that goes from an uncontentious remark about how important the renewables targets are to then saying, and this will shows particularly for onshore wind. So, for instance, in his framework, in his section 2.1.2, he makes that point. He says about international policy, there's consistent policy support at all levels for deployment of renewable energy generally. Well, we're not here arguing that. Nobody's here arguing that. But then goes on to say, and onshore wind particularly. And I don't think you see that in the white paper. And as Mr. Campbell says, obviously we can all read that. But I would also go back to a specific point made about the increase in electrical generation envisaged. And first of all, I would say the Committee on Climate Change very specifically gives different scenarios, but the white paper specifically mentions quadrupling on offshore wind, and I mean that's a very significant increase. And so I don't think there is the evidence that is put forward there for onshore wind and indeed this particular development. Thank you.
Do you want to come back on any of that, or should we go on to the next bullet?
So, sorry, just to respond on just briefly on 2 points there. I think Mr. Campbell's question about why are we here if this is all pointing in one direction. I think clearly the legislative and policy framework is important to understand in terms of the current position and where it's evolved to. So it's clearly important for this recommendation and eventual decision. And in terms of Ms. McDade's point about the Committee on Climate Change, onshore wind is in all the scenarios that the Committee on Climate Change have set out in the 6th Carbon Budget. So the technology flows through them all. And that is the next topic. Are you content for me, sir, just to go on to that?
Yes, let's just go on to that, please. Yes.
Okay. So in terms of the CCC documents, if I can abbreviate it to that, there are several that I've referenced, 5.6. I won't read them all out, but 5.6, 5.11, and then APP 6.7. There's various documents. A number of these are recommendation reports to either the UK government or Scottish government, and it's not so much a matter of putting weight on their recommendations, because their recommendations are to government. I think the key point I would say is that the majority of the recommendations have been accepted by the UK government as set out in the white paper, and also in terms of the Scottish government's enactment of the Emissions Reduction Act, and also the what we see in NPF4 position statement and the whole net zero drive that there now is. And one of the key documents is the 6th carbon budget produced by the CCC as to how we get there as well. The other point, the final point I would say in terms of the matter of weight, is that the various CCC documents were examined in the Paul's Hill Section 36 inquiry report, and that's CD 6.6, and I reference that at my paragraph 2.2.27, where the reporter was interested in that case on those various considerations and decided to give weight to those matters.
Thank you. But if you're saying that the recommendations have been accepted and are now reflected in the white paper and the Scottish Government's Act and MPF4, then I suppose how much do I need to look at these recommendations now if they've all now been fed through into these later documents?
I think that is a good point. I think what is important to note is that the Scottish target for 2030, the 75% reduction, was the will of the Scottish Parliament going further than the recommendation of the CCC. Now, the CCC had recommended, I think, 70%, but the Scottish Government said we need to go further and faster because we're not getting there fast enough. And that the figure was amended to 75%. And that has been commented on by the Scottish Minister, the Energy Minister, as being particularly challenging. So it's this decade that is important in getting to that interim target to ensure that we are on track. And therefore, it's going to be technologies that can deliver over the next few years, this decade, that will contribute to the attainment of the 2030 position.
Okay, thank you. Mr. Campbell, any comments on the Committee on Climate Change recommendations?
I've done it again. I'm sorry. No, thank you. I have no comment at this stage.
Thank you. And Ms. McDade?
Just what I've put in my statement, that the Committee on Climate Change is an advisory body, and I take the point from the applicant that there are very many learned advisory bodies giving reports to the government, and some of them do find their way through to policy. But I am a bit surprised by the applicant's position that in a climate emergency that requires urgent action, you cannot wait for new policies to emerge in years to come. I think that's a bit of a surprising statement to put forward to what is a planning process under current policies, and that's what Mr. Bell says at 2.2.11. And the implication there, I do think, leans back towards what Mr. Campbell alluded to earlier about, well, that does suggest we're all rubber stamping this because of advice that's going to the government, and that's what it is. It is what it is.
Okay, thank you. Can we move on to what the targets are there, therefore, for renewable energy generation? Mr. Bell, if you could enlighten me here, please.
Okay, in terms of renewable energy generation, the Scottish Government target in the energy strategy is 50% by 2030. And the latest statistics on that date from March this year, that's CD 5.30, and they show that the position as of 2019 was 24% had been reached. So halfway there. In terms of renewable electricity, the Scottish Government has had a long-standing target of 100% of consumption by 2020, which is now come and gone. The position there for 2020 was 97.4%. Now, one might take the view, well, look, that's job done. We've made very, very good progress, and undoubtedly, there has been good progress in renewable electricity generation. But as we discussed earlier, that is only part of the policy picture. The outlook is to 2045, and then for the UK to 2050 to get a net zero position. So in many respects, these targets are of their time when SPP and NPF3 were set, and we now have the emissions reduction targets set in the new law. There are no technology-specific targets for Scotland, but we do have, as we just referenced earlier, within the Committee on Climate Change 6th Carbon Budget, scenarios in which onshore wind features, and that is the latest position in terms of renewable energy targets. I think the bullet point had offshore and onshore in it.
Yeah.
As well.
Yeah.
And sorry, just to finish that, in terms of those two technologies, I mentioned the 6th Carbon Budget, which is CD 5.2. Now that sets out the technology broad split, if you like, and the offshore component for 2050 is to reach the figure of about 65 to 140 gigawatts, with an expectation that 2030 that could be in the order of 40 gigawatts. Onshore wind is expected to double in capacity by 2050 to between 25 and 30 gigawatts. So that is where we get a technology modelling, if you like, within the carbon budget.
Thank you.
I'm just going to do the offshore matters. So the whole offshore sector in a Scottish context is dealt with very differently from onshore wind, and essentially through Crown Estate Scotland, effectively their organisation controls the further delivery of sites to meet future objectives. It therefore is undertaken in a slightly different way from other renewable generation. Lots of up-to-date positions that are readily publicly available. Last October, the Sector Marine Plan for Offshore Wind Energy was published, and that essentially identifies the options of where sites would actually go, and that's currently being taken forward in a round of offers to lease called ScotWind, and that process is currently underway, where parties make proposals to develop these to the Crown Estate and ultimately gain an option and subsequent lease to develop them. So there's been quite a lot of work done on offshore wind with strategic environmental impact assessment, etc., working out essentially the extent of wind that could be potentially developed without adversely affecting European sites and other related matters. So in the basis of the current position, in the same month, October 2020, there's an offshore wind policy statement, which is the sister document to the onshore wind policy statement. And it says that the ambition now is that the Scottish Government reckon that 8 gigawatts is the lower end of the range, and that up to 11 gigawatts of installed capacity could be delivered by 2030 in terms of offshore wind. So that's, I would say, is the current position, is up to 11 gigawatts by 2030. The interesting aspect, though, is the massive expansion offshore is also potentially linked to the change that I think we've been through in the white paper, where we've moved on from renewable electricity being a source to displace higher carbon electricity generation, to the white paper seeing the need for that same source of generation, i.e. renewable electricity, to actually displace oil, gas and other forms of fuel for heat, transport and others. And it's interesting that when they look at the offshore context in the policy guidance of the wind policy statement at paragraph 10, that effectively what we're looking at is future forecasts where National Grid post 2030 is saying that we will likely or potentially need 24 gigawatts of offshore wind capacity dedicated solely to hydrogen production. And that's what I mean, that this transition and revolution explored in the white paper is manifesting itself in policy objectives to achieve that transition. And therefore, the figures just look so different from the ones that we've been working to. But that's fundamentally changing because of the nature and scale of the decarbonisation of the other sources of energy and power that's required to meet the climate change objectives. So that's so those are the two documents, and they probably set out the best position as it currently stands relative to Scotland. In relation to UK, it's the white paper that sets the goal, where we've got a target of 40 gigawatts by 2030, and that was up from an original 30 gigawatts by 2030. So the white paper was supporting that higher threshold of offshore wind, which had been announced earlier, but was formally set out in the energy white paper. So those are the sources of documents for the offshore targets.
Okay, thank you. I mean, that discussion of offshore, is it worth rolling in my final bullet there about whether there's evidence of a policy pivot to offshore? I think I've understood from what you said that your answer to that would be no, and that the focus of policy is to do both. Is that correct interpretation of your
My position is that the white paper at a UK level recognises the critical nature of onshore wind and solar still playing a critical role in the mix. I think the and in Scotland too, the policy position is, in my submission, ultimately the same as well. Still strong support for onshore wind. What I think you can see from the white paper particularly, and is also beginning to be generated in the Scottish policy, is the scale of change offshore does require potentially government intervention, and there's other aspects to it as well in relation to grid, which we may touch upon later in a tangential way. But there's quite a lot of investment required, so that's why government has to properly set out these matters, because offshore wind is going to need the scale of the challenges. The supply chain needs to gear up to such an extent that you have to set out the ambition for it to happen. And equally, the government needs to match that with the ambition in relation to grid upgrades and other investments that the government have committed to in the white paper. So that's why it's a slightly different scale. That's why, in terms of the policy, you can actually be clearer in some respect offshore, because we know the future offshore sites in Scotland are largely set out in the marine plan. So it's a slightly different way of doing things. Partly because of the different ownerships of the underlying seabed and how that operates.
Okay, thank you. I'll come to Mr. Campbell first, and then I'll come to you, Ms. McDade. Mr. Campbell, your views on these matters. Sorry, I didn't hear you again.
For the reason that it's not appropriate for a local authority to join this debate. I may sound like opting out of the discussion, but I have views, of course, but you don't want to hear those. They're of no relevance to the inquiry. The local authority doesn't and couldn't contribute to this part of the discussion. except in a very general way. So I don't want to waste your time with that.
Very well. But I think Ms. McDade has some views. So we'll turn to you, Ms. McDade, please.
Yeah, it's not about views, it's about just a comment that I absolutely accept the targets that have been quoted. I'm sure Mr. Bell is absolutely correct, and Mr. Innes' discourse on offshore is very interesting. I suppose the main point I would like to point out is that we have just talked about renewable energy generation targets, and on your question, you've got in brackets onshore, offshore, and you know it does include solar, heat pumps, CCS, nuclear. And you know, I think it's important not to get diverted into thinking whenever renewable energy is mentioned, that it clearly is support for Clauchrie going ahead. This is so you know that I just would make that point. And in regards to whether there's a policy pivot to offshore, as the question puts it, I think there's no doubt the UK government is absolutely determined to see that expansion go ahead. And as I say, I'm sure we all accept that there will be more onshore wind. I think what is more debatable about what Mr. Innes has put forward is that there will be more money in the pot, the CFD pot, to fund many onshore wind farms. And he's right that some gained funding in the last round. One or two major schemes which have been around for a long time did not. So, you know, unless you think there's going to be a lot more money in the post-COVID world, I think there'll still be quite a fight. And the question for this inquiry, I would suggest, is whether Clauchrie is a good bet for that and is a good one to put into that mix.
Okay, thank you. So I think on this item, we're still missing the point about the declaration of a climate emergency affecting decision-making balance in this case. We possibly touched on this a little bit this morning, but we'll come back to it now. Mr. Bell, on this point.
Yes, thanks, sir. I'll try and keep it reasonably brief. My answer to the question would be yes, it is a factor in the balance. I have referenced another decision, the Crystal Rig Section 36 inquiry report, which is very recent, APP 1.8, where I quoted my paragraph 2.2.31, where the reporters concluded that the development in that case was supported by national energy and planning policy, and they added it also attracts support from recent developments in response to the declaration of a climate emergency, particularly it went on to say the 2019 Act. So the declaration of the emergency, in my view, needs to be viewed in the context in which it was declared and what followed from that declaration. It's not simply a political declaration or soundbite. It is an overriding priority in many respects of government policy, and we see it referenced now through the NPF4 position statement. I think it reflects the seriousness of the global heating issue and the desire for, and indeed the legal objectives now for net zero. And again, I would say that it did not wait for planning policy to catch up. The government acted on the emergency declaration. So in many ways, I think it would be inimical to follow what might be a business as usual approach by just resting on SPP and NPF3. It's clearly a good illustration of a factor that has come into play. Now, one further point, just to reference it, the energy strategy position statement that was issued in March, and that's APP 6.2, as an introduction from the Energy Minister. And whilst there is reference to the economic crisis, it also states that the climate emergency has continued unabated. And the need is then set out for net zero and sustainable economic jobs. The need is quoted as being greater than ever because of that emergency context. So I would say it's not just a material matter. I would say it's a factor of considerable importance to the case today. And of course, it's not a trump card. I think, as Mr. Campbell and Mr. McDade were saying, fully accept this is not an overriding policy position that means any development can proceed. There are clearly environmental factors to take into account, coming on to talk about that. But it is a factor that carries force and weight and should feature, in my view, as one of those factors in this case.
Thank you. Mr. Campbell, is this another area where you don't feel you should be taking a view?
It's not a view, it's an opinion and advice to you. It seems to me that the expression climate emergency was designed by the First Minister to write a headline, which she did very successfully. What is missing, again, is the connection between this proposal and any effect on global heating. Obviously, with a coming demand, as we've seen from Mr. Bell's analysis of the Climate Change Committee on Climate Change's papers, obviously with a growing demand for power, there is and there will be additional power installations onshore and offshore. You can have an opinion about whether it's an emergency or not, whether we should move faster in this decade or more slowly over a longer period. My question is, as a lawyer, is does this affect your? Can this in any way affect your decision and make it more likely for consent to be recommended to ministers because there is a climate emergency? I think, sir, if you did that, you would be enslaving yourself to what is, after all, in the end of the day, just a political statement. Just a political statement. Because it lacks analysis, it lacks qualitative and quantitative analysis. All we can say is that global warming is active. It's active in other parts of the world. Will this proposal make any difference to it? Well, we don't know, and the applicants don't know either. If there are environmental considerations which tip the balance the other way, as we say there are, then that is the way your decision should go.
Thank you. Ms. McDade, anything on this point?
I would agree with Mr. Kelly's point in his statement that there's been plenty of time for the government to change their policies. Yes, there is a process going on, but it's going on at the usual governmental rate. But if they had felt so inclined and thought it was so urgent to change this consideration and to materially change your decision making, then they would have done that. And so I can't agree with Mr. Bell that this trumps all, and then therefore you have to, okay, not this trumps all, but this is so significant, then you as a reporter have to make up your mind what that would actually mean in policy. I mean, the policies are there. It's clear. There's an update on MPF. No, I don't agree at all. I think that dispenses with policy and leaves decision makers all over deciding which bits they'll pick up.
Okay, thank you. I think we'll take a break soon. We'll finish this item 4 first. So I think the only one we've got left to look at is around statements and energy policy regarding environmental protection. I could start with the applicant on this one, please, Mr. Bell.
Thank you. There are clearly various documents that make reference to environmental considerations. The onshore wind policy statement is one. I think the Scottish Energy is that are to be acceptable for it to come forward as an application, and that is also the further role of in the inquiry process to test that. I think what we described this morning was the policy approach that the government set out in land use planning, and that is that there are clearly some no-go areas such as national scenic areas and national parks. There are Group 2 considerations which are quite long in their list, from battlefields through to mapped interests and we're dealing with two of those mapped interests in this case. And also we have group 3 areas where wind farms are likely to be acceptable, but subject to development management criteria to be applied. We've also got a further level in this case, and that is the landscape capacity study, which provides a strategic guide. And there's a level of agreement amongst the parties that provides an indication that this is the right place for this type of development. So is it the right development in the right place? I think we've answered the place point. Is it the right development? The EIA has gone into various considerations, as Mr. Innes explained earlier, and we have a position now from consultees and a position set out in evidence. So the environmental factors have been fully considered, and the applicant's position is that the effects arising are acceptable, and that is consistent with the various policy considerations that deal with the environmental matters through land use planning and in terms of the energy policy document.
So to sum up on this item then, really, would it be fair to say that decision makers have always been tasked with that balance between the benefits and the potential environmental costs, and that what's happening in the direction of travel on energy policy is just adding a few more coins to the balance in favour of giving more weight to the benefit side of that equation?
Yeah, I think that's fair. As chartered planners, we are very well used to dealing with varied considerations and attributing weight in different ways to those considerations. So if put another way, one might say that in today's context compared to 2014, it needs to be more of an adverse effect occurring today to withhold consent if we're putting an extra bag of weight on the positive part of the scales. That's not to say that the weight to environmental considerations is less, but you're attributing it less. But clearly, in any planning determination, one has to make a judgment on where the weight lies.
Thank you, Mr. Campbell. Anything on this?
Almost philosophically, Mr. Bell invites us to compare apples with pears. More of an adverse effect in order to withhold consent is what he said. Yet how do you put on opposite sides of the scales the climate change imperative, the imperative for more renewables, the imperative for more bigger and more powerful generation on one side of a balance, and landscape and other effects on established interests on the other? They are not two versions of the same thing. They're different things. What's happened here is that there is a range of established interests already established and entrenched in the community, both at an individual and at a local authority level. Along has come wind power, and the local authority has recognized that this is for the government, the elected government of the country. For the government, this is something of an imperative. And so they have devised their policies so to admit that imperative, despite the existence of these established interests. Clauchrie and Clauchrie are two examples. But there's a line which can't be crossed, because, as Ms. Anderson and Mr. Edgar have pointed out, and indeed Ms. Lobban, the Environmental Health Officer, has pointed out, when you trespass too far on established interests, then the balance tips back the other way. You can put a wind farm of this size in many, many places in Scotland. It doesn't have to be here, where it trespasses over so many established interests. Now, the only other thing I want to say in this part of your agenda is both the onshore wind policy statement and Scottish energy policy date from 2017. Neither is very strong on environmental safeguards, but both do contain caveats about the right wind farm in the right place. The white paper changes everything. The Committee on Climate Change changes everything. But if we were looking to analyze, again, as lawyers, what is a true policy document, then those are, I think, the latest true policy documents issued in Scotland, 2017, the single exception of the amendment to SPP in December 2020. The UK white paper is just a white paper. It's a statement of government intention. It's a statement perhaps even of the policy which will be incorporated when government intention is realised. But it isn't legislation. It isn't even official planning guidance. It's got some way to go.
Thank you. Mr. McDade, anything at all wrap up on item 4?
Yeah, just on a couple of points on that. One, I would say Mr. Bell referred to the landscape capacity study, and I would doubt that at that time 200-metre turbines were envisaged, and so obviously there's a difference there. So there isn't a blanket acceptance that this is the area for these things. And I would also thought that perhaps Mr. Bell contradicted himself there, and he can correct me if I'm wrong, but on the one hand, he said, yes, there should be more weight on the increased imperative to go forward with this kind of renewable energy, but that didn't mean that there was less weight on the environmental side. It didn't diminish that. Well, anyone who's looked at scales, it obviously would. And just so on the environmental point, I would, support what my colleagues, Mr. Shaw and others, put forward in previous parts of the inquiry. Particularly on the wildland issue and the forestry issue. Wildland in Scotland is one of its most unique areas. We've talked about the peat aspect of that, but also the wildland visual aspect of it. And it is not true to say that if you put it on a bit of the wildland, but it's the less important bit, it doesn't diminish the whole. And that argument, it does, and that argument applies across the board. So I think Mr. Bell's evidence does suggest that they are putting forward that there should be less importance given to the environmental protection.
Okay, thank you. I'll let Mr. Bell come back, and then we'll have a short break. Mr. Bell.
I think just to clarify, one can place more weight on the benefits of a given development. It doesn't mean that you're giving less protection to environmental considerations. And the reason I went through the spatial framework approach was that we have specific tests to satisfy in terms of environmental considerations. So that is what I mean by respecting those and following the land use planning guidance on those matters. But at the same time, it's open to a decision maker to place additional weight on the benefits if that is relevant in a given case.
Thank you. We'll take a short break there and come back at, well, say 3:10, please. Welcome back. That's 3:10.
Thank you.
Yes, you're all coming up on my screen again now. That's good. So we're moving on now to item 5. Now I'm slightly conscious of time here. I don't want to keep people too late. We've still got a few items to get through. So if people could bear that in mind in giving their answers. But we'll kick on with item 5. And question to Mr. Bell, nice simple one, is need a material consideration, Mr. Bell?
Yes, it is. And I've got just a couple of comments on the Chief Planner letter in your
Go ahead.
questions. I think this letter came about at the time of in 2015, where there was strong hostility from the Conservative government, well, in fact, it was the coalition government at the time, against onshore wind. And as Mr. Innes has said earlier, that position has changed somewhat, but the reference in the first line to the Secretary of State, Amber Rudd, is part of that, where there was a position that there was enough onshore wind to meet the target that was set out in the route map for renewable energy set by the UK government. And a number of planning authorities at the time were leaping on that, and third-party objector groups as well, saying that, you know, it's quite clear there's enough onshore wind to meet targets. We don't need any more. There's enough consented capacity. Really very limited, if any way, it should go to the benefits of this development. The Chief Planner was saying, no, that is the wrong approach. The Scottish Government policy is clear, and furthermore, there is no cap on the targets that have been set. And that was specifically the 100% target by 2020. And as we've just discussed today, the context of targets has changed considerably.
So how does the, I've seen the references to the Gordon Bush decision, where it seems to be stated in terms that need is not a material consideration. How am I to read that?
Yes, I think one needs to read that in context. I think Mr. Kelly has raised that a number of times, but in short, I would say that is a distortion of the decision. It's not what that decision is saying. In that decision, it was a Section 36C variation seeking to make some minor amendments and in fact reduce the scale of that development in terms of the number of turbines, as well as make some modest changes to access tracks and so on. So the whole question of need, if you like, had already been addressed for the base consent of the Section 36 development. So when one properly looks at that reference that the Scottish Minister made, it needs to be read in that context.
Okay, thank you. We go around others then. Mr. Campbell, you agree that need is a material consideration? I think you're on mute again, Mr. Campbell.
Yes, but it is a material consideration, but you have to define what you mean by need. And need and the abolition of targets are not the same thing. That's the first point I would like to make. The second point I would like to make is that the Chief Planner's letter is directed to local authorities, and it's not policy anyway. It's simply an administrative measure. By convention, it has come to, Chief Planner's letters have come to be matters which local authorities pay attention to, but in no legal sense are they binding. They are official guidance. The Chief Planner in Scotland rushed that letter out after Amber Rudd abolished the subsidy regime for onshore wind because of pressure in England. And as Mr. Bell quite rightly says, one or two local authorities in Scotland jumped on that bandwagon. but I don't think in the context of Clauchrie it's important at all, and you'd be well advised just to ignore it. Thank you.
Thank you. Ms. McDade, anything on this?
Just that the sentence in the decision letter for Gordon Bush Extension is there for your interpretation. The needs case for the proposed ferry development is not a material planning consideration. So, you know, it's quite specific.
Thank you. Come back to you then, Mr. Bell, to look at the next couple of bullet points, please.
Thank you. I think the first one I've got progress to renewable energy targets. I think we actually covered that earlier, so just with the 2030 target reference. Are you okay with that?
That's fine, yes, that's fine.
The second one is, does the large capacity of unbuilt consented schemes lessen the case for further consents? And I think one might say, well, look, gosh, it does. There is a large capacity of consented development that has to come into play. Well, the Scottish Government has consistently stated that and made it clear that whilst there is, yes, a large volume of consented capacity, not all of them will come forward for a variety of reasons. Some will be commercial, some will be landowner related, and some funding related as well. So a number of them will also require reconsenting, and that is evident with the large number of, we did see a large number of Section 42 applications coming forward to seek to vary tip heights, and we now see new fresh planning applications coming forward for that, given case law implications for the Section 42 approach. And that is because the route to market is has been more challenging for the reasons Mr. Innes set out, in terms of the contracts for difference being withdrawn and then now coming back in, which means that the viability of a number of the lower height consented developments was very challenging. And we see that in the onshore wind policy statement in terms of the importance of a route to market. Now, what I would say is that the applicant SPR has been able to bring forward sites since the CFD changes, and the applicant is not in the practice of being a developer trader and simply selling on consent. They build out projects and they don't land bank consents in the way many house builders might do. And I think one of the key principles is to get projects right in terms of all the various environmental and implementation considerations, so that they can be built. And the evidence for that is out there with the Halsery scheme in Caithness just complete, and Ben and Turk 3, both of these projects delivered without market support and implemented. So the capacity of unbuilt of consented schemes is there, that's acknowledged, but no significant weight should be placed on them for those reasons.
Thank you, Mr. Kelly. No, well, I don't think Mr. Campbell. Sorry, I thought Mr. Kelly.
No,
Mr. Campbell.
I don't have a view on this.
Okay. Mr. Kelly, you have appeared now. Have you got any view on this point?
Nothing to add. I mean, we're basically just hearing what's in the hearing statement, so I have nothing to add.
Thank you. And Ms. McDade?
Similarly,
nothing. That's good. So that takes us on to this point about the significance of Clauchrie, and I suppose this comes down to the balance again. And if I mean, one often sees reference in decisions to the useful contribution that schemes will make to the renewable energy targets. And I suppose it's just an idea from the parties about how much weight I should give in this case. I mean, this is a 100 megawatt scheme and is therefore larger than many others that one might see. So does that mean I should give more weight in this case to the benefits than I would in another case? Mr. Bell.
I think in this case, we're dealing with 100 megawatts of capacity for generation and also 25 megawatts of battery storage system. And one can take the view that is effectively twice the threshold for Section 36. It's the equivalent of 5 major applications under the hierarchy regulations. That scale of development, I think, can reasonably be stated to be strategic in nature, one of the bigger types of development that is coming forward. And the one added benefit of that scale is the consequent scale of emission savings. Should that volume of renewable capacity get onto the grid and start to be used. It also allows at that scale for meaningful dealing with necessary mitigation and also habitat management. Some parties may say, well, this is simply a single development as well. In the face of these targets, why is it attracting weight? Well, I think if that approach was taken to every project that came forward, we wouldn't really be making great progress. So we know SPP at paragraph 169 looks for reference to the contribution that a development would make to targets. That has been able to be quantified. And the added element here, which isn't always seen, is the battery storage, which makes the use of that renewable energy even more useful in terms of when that can be delivered onto the grid.
Thank you, Mr. Campbell. Anything on the significance of Clauchrie in the round?
Not in that, no. Thank you.
And Ms. McDade?
No, I think you have to consider the efficiency of Clauchrie, and we'll be coming on to that load factor.
Yeah. Okay, I think future change in electricity demand, I think we've covered that in looking at the graphs of future demand. Exporting power from Scotland, I suppose what I'm thinking about here is that there's an acceptance of a potential impact on local communities from the development of wind farms, and in return for that, one gets renewable power for those communities. But if the power is being exported to England, which is still part of the UK, of course, does that change the planning balance at all? Mr. Bell, do you have a view on that?
Yes, I think firstly, just as a general point, there's no other land use type, to my knowledge, that needs to consider its export potential or ability. It's simply not a land use planning matter. And in any event, I would say if something is capable of being an export, then surely that is a positive thing for the country. But notwithstanding that observation, the grid system is a GB system. It's an integrated GB system that is regulated. So it's not a matter, I would say, that is a relevant consideration. And we can see in SPP that the Scottish Government has been clear that grid matters and grid capacity, paragraph 176, is not a matter that should feature in either spatial planning for wind energy as per the spatial framework or in individual decisions on applications.
Thank you, and we'll come on to that in the next item. Mr. Campbell, anything on this?
No, I agree with Mr. Bell on that. Thank you.
And Ms. McDade, do you agree?
I do, just on the future change in electricity demand, and I'm sorry if I should have put this in before, but of course electricity consumption went down 5% last year. And, so it's not always necessarily that our consumption is going to increase, and we live in hope of finding ways to live without continuing to use more and more electricity, however it's produced. Reduction is the most cheap way to achieve targets.
Thank you, and I think that's.
I just had a brief point on that. I think we need to put that statement into context. I think consumption did go down and emissions did go down last year because of lockdown. That needs to be acknowledged to put that statement into context. And the expectation we know from the white paper is that demand is going to grow massively, and we saw that in the graphic earlier.
The final bullet on item 5 is comparing with other renewable technologies. I think Ms. McDade's already made that point. I don't know if there's any further comeback you want to make, Mr. Bell, on that.
Sorry, you just broke up slightly at the end there. Could you just repeat that?
Sorry, I was just asking you. I was saying that the final bullet on item 5, Ms. McDade, I think, has already made that point, but I'll certainly let her expand on it in a moment. But whether you had any comeback on the point about that there's other renewable technologies that can fill the gap.
I don't think so, sir. I think we've covered that before in terms of the role of onshore wind, so I'm content with that.
Okay. Thank you. Mr. McDade, can I move on, or any further points you want to make on that?
No,
Move on.
Yeah.
That takes us on to item 6. And first of all, the likely load factor for Clauchrie. And Mr. Bell, am I right in understanding the load factor? That's a measure of the efficiency, essentially, of the wind farm, is it?
It can be, but I think a considerable degree of caution needs to be given to that. The load factor is essentially the amount of electricity be generated from a wind farm compared to the amount that the turbines would have generated had they been available for the whole of the year running continually. So if I draw an analogy with a car, for example, you have a car that can probably drive 100 miles an hour, and theoretically you could drive it at that speed all year, every day. But clearly that nobody does that. The average speed is probably 50, and it's driven 4 or 5 days a week. So with a wind farm or a turbine, it's predicted availability and timing against what it could theoretically run at 100% of the time. That is in effect how the load factor is measured, but it changes by turbine class and clearly depending on the wind regime. Now, there is met mast data which has informed the Clauchrie project, and the figure is around 36% as a load factor, and that can be compared against the UK average in 2019, which is set out in CD 5.13. That's the base digest of UK statistics, page 93. It shows the UK figure in that year was 26%. So Clauchrie is a good site. It is a good wind resource which can be captured, and insofar as that is a relevant consideration, that is the data that is available.
And is it a relevant consideration for me?
I think that the matter of efficiency, if you can call it that, was postulated in the consultation on the onshore wind policy statement, and the government decided not to formalise that in planning policy in terms of comparing one site against the other. I think probably recognising, in a lot of industry representations made the point that you cannot simply say the factor is a certain percentage, because it will vary depending on the final turbine choice. And therefore, I think one has to be fairly careful on how one would apply that, especially, say, in a cumulative context or a conjoined inquiry. But we're not in that situation. Where we are is that there is met mass data that is reliable, and that shows us that it is a good site in terms of wind resource. And, you know, that may be a matter that the ministers wish to place some weight on, should it be reported to us.
Okay, thank you. Mr. Campbell, anything on this? No. Ms. McDade.
Thank you.
I just wonder a couple of things. I've, in my statement, I've included load factors of neighbouring wind farms, 3 of which are Scottish Power, and I wonder if Mr. Bell knows what estimated average load factor there was for those SP ones when they were at inquiry, because like many things, it's one thing to have theoretical data and put forward an optimistic interpretation, and it's another for that to be delivered in the world of engineering and so on. So I'm interested to know if he has those figures that he could help the inquiry with, and also whether he can tell us another mainland onshore wind farm that does produce a load factor of 36%. I say mainland because we always quote the Shetland one, which produces about 50%.
I don't have these figures. And in terms of other wind farms, certainly a number in Highland will be in the Monolith areas, will be producing in that range, and certainly in Caithness up probably in the high 30s, low 40s. And then in Shetland, very definitely in the high 40s, and Orkney as well.
Can I just be clear that when we're talking about these load factors, this is looking purely at meteorological matters, is it? It's not looking at switching off of turbines when low demand, for instance. No. Yeah.
The reported load factors do obviously get reduced if there's been a shutdown for a significant amount of time. I'm fairly certain that's the case, but Mr. Bell can correct me if my understanding is incorrect. I think that's one of the key points about how often they're constrained off. That's why they have poor load factors, amongst other things, I thought, but I'm happy to be corrected.
I think a very detailed energy yield assessment will look at various considerations, including wear and tear and average downtime for annual maintenance in a year. These will be the factors that will go into it.
Yeah.
Thank you. Now, coming on to grid capacity. I think I heard you say earlier, Mr. Bell, you're quoting from Scottish planning policy, I think, saying grid capacity wasn't a material consideration. Is that correct?
Yes, I think looking at my notes, I gave you the wrong paragraph reference. So just to say paragraph 165 of SPP is the reference. Now, this is a matter that's been raised at a number of inquiries, and as far as to my knowledge, it's been a consistent approach taken by reporters, and indeed the ministers, not to place any weight on alleged grid constraint matters, or indeed the specific matter of constraint payments.
Thank you, Mr. Campbell. Is this something I should be taking account of? No.
No, you shouldn't.
No. Ms. McDade.
I believe Scottish planning policy covers this when you're looking at sustainable development. I think efficiency is referred to, and I'll put in a closing submission since I don't have a paragraph.
Okay, so can we then skip the next 2 bullets then, if we agreed that grid connections aren't relevant, and come on to
So
yes.
So it was just for I think we can do that. It was just to reinforce the point. This argument was advanced at the Falago Rig inquiry, which is CD 6.14, and the reporter's conclusions on energy policy deal with this. So I think I would suggest to you, simply for the matter of consistency, given the ministers accepted the reasoning on this from the reporter as their own position. It's the inquiry report, paragraph 3.108, where the reporter dealt with the matter of grid of constraint payments and grid.
Thank you. Ms. McDade, you also had your hand up.
Yes, no, I don't agree that we should just skip these 2 points. And I think it does come under Scottish planning policy. You know, there is about the right development in the right place. That doesn't just apply to environment. That also applies to if you put something in the wrong place, then you're not only damaging that place, but you are taking away that opportunity from somewhere else. And the constraints payments, you know, is a matter for Scottish Government to consider whether these are efficient sites. So, I mean, you know, if you've decided that you're not looking at that in detail, fine, I've put it in my statement, but I think it would seem under Scottish planning policy and about the right place, then you have to consider whether this is the right place, not just for environment, but also for the Scottish nation. Whether it would be better if a development like this was elsewhere, where these things which impact on efficiency didn't come into it. And I mean, you have to take into account that, you know, wind farm like Kilgallie was constrained off for 20% of the time last year. Is that the way to go about planning? That's obviously, you know, for you to decide. But and I suppose I particularly would suggest that just because other reporters have decided that in those instances, when reports have gone in favour of something that objectors say, it is often said that, of course, this is not like law. It's not case law, because it was decided that in one inquiry does not mean, and things go on. These factors become more important. So I am asking you to consider it.
Yes, I'm happy to have a conversation about constraints payments. Well, I mean, I'm not saying I'm accepting it's necessarily relevant to my decision, but I think I'm willing to have a conversation about it. So, I mean, the question I put there is whether that question is one for me, or whether the issue about the financial efficiency, if you like, of the wind farm is one that is for consideration further down the line. Ms. McDade.
Well, clearly, in terms of finance to the company, that's the company's decision, and in terms of cost to the country, that's for the minister.
Yeah. Okay. Mr. Innes, do you want to say anything on this matter?
Yeah, I'm going to put this in its proper context. Grid matters have their own regulation. As we saw, a whole system's been put in place under the Electricity Act for the Secretary of State and Gemma through Ofgem to implement. And there's a whole system in play. We have a clear structure for delivery of grid infrastructure. The National Grid Electricity System Operator acts as essentially the overarching body that looks at the system as a whole. We then have National Grid Electricity Transmission Limited, which owns transmission assets in England. We have Scottish Power Transmission that deals with transmission as an owner in its area, and Shettle for Scottish Hydro. In terms of the structures and responsibilities, effectively the whole generation system is considered, and then these bodies plan our future grid. And so each year, National Grid ESO has to carry out system planning in 3 stages. It starts off by looking at future energy scenarios. And at the current time, one of the key scenarios is what does the grid look like to achieving net zero by 2050? And that's consulted upon. It's published usually in July. And there's discussion about the likely scenarios. We then have also a 10-year statement, which is part of NGSO's annual electricity planning cycle, which is setting out the likely future transmission requirements of bulk transfer of power flows. And then also each year we have the NOAA, which is the Network Options Assessment, where very detailed evaluation is undertaken relating to a whole range of connections and it takes them forward for consideration into the next stage of project planning and ultimately projects that are committed to. So in terms of the whole process, there's a very structured process for grid. And as one of the key objectives of the whole system is to encourage competition and allow generators on fair and equal terms, Scottish Power have applied for a grid connection for Clauchrie and have one, and have a grid connection date of 2025. So that is all through the system, and that demonstrates that there is an effective grid and that we will be able to connect. I want to now just come back on a couple of issues about constraint, because when Mr. Day talks about Kilgallia being constrained off, you might get the impression that it's being turned down because of a localized constraint. But in terms of the overall management of the system, at certain stages, the party in charge of the grid will have to turn down the volume of generation coming on. And because the grid has to operate economically and efficiently, it doesn't just randomly select people to turn down. There's a process of bidding in to potentially be turned down and receive constraint payments. And if you are the cheapest, then you will get taken to be constrained off, because that's the most efficient for the system for that to happen. So the idea that constraints are only paid because there's a local constraint is not quite true. There is usually on any given day there'll be constraints in the system depending on what the balancing those demands are. But that is a matter which grid pays for across the piece, and effectively it does have to pay because the generator has paid very significant sums for its connection agreement, and it has to know that it can continue to generate and to plug into the system because that's what it's paid for. And the question is, who carries the risk of matching and balancing the overall system? And ultimately, it's the grid as a whole carries and manages that risk. And effectively, the generators get that guaranteed position, because otherwise, if they were having to carry that risk, you can imagine the project economics would be very challenging if at the end of the day, you spent all your capital and yet you couldn't run because the grid wasn't good enough. So it would be a counter to this. So all that the generators get is very close to what they would get if they were generating, and that's what it seeks to match in terms of not generating. And it's quite right that they get paid because they've paid for this firm connection. So I hope that sets out a bit of the context, how it's not right to suggest that there is a particular problem here just because Kilgallia is constrained off. It happens to be a relatively large scale wind farm, and therefore if there are constraints, it is one of the cheaper ones to turn off in terms of getting that generation off the system. And that's why it's often used by National Grid in that context to provide that opportunity of turn down. The other fundamental point is that looking at things over a very short timeline is not how grid's done. It's forward planned, a long time ahead, and that's what they're currently doing now, is trying to make the next set of grid that we have for 2030 fit for achieving the changes that we're going to see. We're all going to see a lot of generation coming off still. There's still a Scottish nuclear plant that's going to come off north of here and north of the site. And equally, by 2030, to honest, if it's going to continue, we'll have to get life extensions. So there's that whole point of generations changing, the generation mix is changing, the demand profiles, if you take the net zero, are going to change. That's what grid does, and grid manages it in a totality, and that's why it's done in the way that it's done. It therefore is not and will never be appropriate for this to be drawn down into every individual decision making in respect of projects, because it really you wouldn't have the time to go into all the documentation to understand where things sat at any particular point in time or how the network's going to change. That's a matter for grid that's set out in the Electricity Act, and that's why it can never really be a matter that's ever relevant to an individual generation proposal.
Thank you. Ms. McDade, do you want to come back on any of that, please?
Yeah, sure. It's interesting that we have the time to discuss international advisory bodies at great length hours, but we don't have, quarter of an hour to discuss constraints. And I mean, I'm grateful to Mr. Innes for pointing out that you have to look at who the risk lies with, and that, of course, in this case, the applicant needs that surety that if they're going to be constrained off, they're going to be well paid for it. In fact, paid better than if it was a nice windy day, and that is a matter for national policy and it is a matter for grid. However, if Kilgallia, if it was the 20% last year, and you build another wind farm not very far from it, which is we've decided is a significant size, 100 megawatts, and you know, the grid expansion has not come. Scottish Power was turned down for a larger expansion not that many years ago, and the cable that has been put in, the Hunterston cable, and I commend that paper that we've lodged to the reporter, did not do the job that it was going to do. So you're right that grid will almost certainly expand, but in the meantime, someone will have to be carrying that risk, and the risk is, of course, to the public. And I would make the point that in the uncertainty of whether at some point Scotland might become independent, then you can't say that this cost will necessarily be carried by the whole of the UK as it is at the moment. So I think it is a matter for Scottish ministers, but obviously, Mr. Hall, you'll decide that for yourself. But I do commend that paper to you, the SKS 11.3. Thank you.
Thank you. But I'm just completing my notes. Thank you. Then, if nobody else has got anything to add on item 6, we'll go on to item 7, which is the carbon balance. And if the applicant could perhaps explain to me how the carbon balance has been taken into account in this application, please.
Thanks, sir. I think I referenced carbon figures in the benefits for the proposed development, but I think in terms of your specific question of what does it take into account, Mr. Darnborough is still available and he can give a more expert opinion than me on those particular matters.
By all means. By all means.
Yeah, so in terms of the carbon balance, what we've done is we've used the carbon calculator, which is CD 1.533. And actually, it's detailed in chapter 14, which is CD 1.1.15, which is the other chapter. So the carbon calculator is published by the Scottish Government and is considered the acceptable tool to use to determine the carbon balance for renewable projects. And in using this, it's important to note that SEPA and NatureScot raised no objections in regards to the carbon balance for the proposed development. And I think if I'm correct, you were keen, sir, to understand what was included in the carbon calculator.
Yes.
So it considers the fabrication of turbines, emissions arising from construction, that's transportation, quarrying, etc. The indirect loss of carbon dioxide by plants that are on the surface of the site, so that's the removal of vegetation or the destruction of active bog plants. It also considers carbon release from heat due to drying or drainage, and also the loss of carbon due to drainage of the site from forestry clearance. And what we found was that the proposed development is expected to take 2.8 years to achieve a carbon balance or carbon neutral.
Okay, thank you. Okay, thank you. Thank you. That was it. Thank you. Mr. Campbell, do you have any comments on this item?
No, thank you.
And Ms. McDade?
No, thank you.
No, I don't think I've got any further questions on that one either, so thank you for that. Now, we dealt with the planning policy items, so that takes us on to item 12, which is about benefits, of which we've just discussed CO2 savings. And I think we've discussed renewable energy generation quite extensively, and economic benefits I've discussed at the socio-economic session. And energy storage, Mr. Bell has mentioned as well. So Mr. Bell, I don't know if there's too much more to say here, but are there any additional benefits you want to highlight to me? And again, consideration of the significance that I should give to these items.
I think my chapter 5 provides a hopefully helpful summary of those. I think the energy storage point or element is important, because that will help balance the intermittency matter, and also what we talked about earlier in terms of when Mr. Innes was explaining about the way the grid can operate. So when electricity demand is at a low point, but the resource is high on the site, energy can be stored, and then it can be released when demand is high. So the energy storage element helps further enable the attainment of renewable energy targets by deploying that energy onto the system when it is most needed. It provides that balance and flexibility. So that should be attributed weight, in my view, for the reasons we've explored today. Otherwise, I think you should have a comprehensive summary of the benefits set out in the collective evidence.
Yes, I think I do. Mr. Campbell, anything on this item?
Don't think so, thank you, no.
And Ms. McDade?
Just one short point, because I won't be at the other session. Mr. Bell in his section 2.2.23 referred to the green thread and the need to substantially increase renewable capacity and take advantage of renewable and low carbon sector to drive the green recovery. And so I would like to refer you to the document lodged SKS 10.1, which is a very recent STUC report by the STUC and the GMB called Broken Promises and Offshore Jobs. It doesn't refer to offshore wind, it refers to offshore jobs. And that concludes that the renewable, well, the onshore wind sector specifically, I think, has done very badly in providing those jobs that were promised. And you look at BIFAB and so on. So there are two sides to that rosy picture. Thank you.
Thank you, Mr. Bell. You wanted to come back on that?
Yes, just quickly. So I would just say we are dealing with this project, this inquiry, as we know, and as Mr. Innes said, the grid connection date is 2025. So that's important for two reasons. It can allow the development to be, should it be consented, to be implemented and contribute to that challenging 2030 target, but it can also make a contribution to the green recovery, which will be projects that are developed out over the next few years. And as you know, for the reasons Mr. Blackett set out at the hearing session, that's important, and it is a thread, very much a strong thread through the various government policy documents that we've referenced. Thank you.
Okay, thank you. Then I'll move on to final item, any other matters. And the first bullet point there about Scottish Minister's potential conflict of interest. Mr. Kelly, this was a matter that you raised, I think due to the ownership of the land by Forest and Land Scotland. I'm not sure what the consequence really is for me, though, in making my recommendations.
So the consequence for you is that I'm asking you to recognise it as an issue. You're correct that it's ultimately a matter for Scottish Minister to set out clearly their financial interest in the project and how they've accounted for that financial interest in their decision making. But in terms of you, sir, all I ask is that you recognise it and report it as an issue.
Right, thank you. Mr. Bell.
So I would just say the fact that a government agency owns the land on which a development is coming forward on does not make it any more or less acceptable in land use planning terms, and that is what you're charged with dealing with, as we know, is the land use planning matters. Other matters may or may not be for ministers to deal with, but not for you, I would suggest.
Thank you. Then the next bullet point there, is the likelihood of the scheme being developed if consented a relevant factor? And that may or may not have some cross-reading with the subsidy regime. Mr. Bell on this one.
Yes, I think we touched on some of this before. The applicant has got a track record of delivery of projects that have been successfully implemented. Also, some in a subsidy-free context, and give some examples of that. So that is a principle that is core to the business, and I think that can provide increased confidence and weight that the scheme will be delivered. And the consequence of that is the contribution to targets, the green recovery, as I've talked about. So I think that is a relevant consideration.
Okay, so even if okay, no, I understand that. That's fine. Anybody else on that one, Mr. Campbell?
No, thanks, Tim.
Nothing on that, Ms. McDade.
Just that I think you can't rely on the past history of Scottish Power's development to ensure about going forward. They've got a huge number of applications on the go at the moment, and I think I'm correct in saying, you know, that's at speed of scale in this part of the planning process that we wouldn't have seen before. Again, Mr. Bell can correct me if that's not the case. So we can't be sure they'll all go ahead. I think it would be a relevant factor. In a sensible planning world, it would help if we knew which of the ones we all spend a lot of time on actually are going to come to fruition if they get consented. But I'm not sure that you can know that.
Thank you. And then energy storage. I know, Mr. Bell, you've referred to the energy storage component of the application a couple of times. But can you direct me to any particular policy position on this?
I think, yes, I think paragraph 169 of SPP, sir, is the key one. It's a consideration for you to deal with.
Okay, thank you. So anything else anyone feels they wanted to say they haven't been given an opportunity to say today? Mr. Bell, anything you want to add?
No, thank you very much. That's been very comprehensive. Thanks.
Good.
I agree with that.
Mr. Campbell.
I agree with that. I have nothing to add. Thank you very much for taking so much trouble over the detail of the policy issues.
No problem at all. Ms. McDade.
No, I have nothing further to add.
And Mr. Kelly.
Nothing further to add, sir. Thank you.
And Dr. Gordon.
Yeah, it's not to do with today's session, sir. So I don't know if you want to conclude the session before I raise my point. It's just
no, go ahead. Go ahead.
It's just that I won't be back with you until the afternoon of the 23rd now, where you're going to give information on posting submissions.
Yes.
I just wonder if prior to the 23rd, I'm not looking for it now, but prior to the 23rd, you could perhaps indicate what time the afternoon session would begin, so that we're not kind of randomly hopping in and out to try and find out when the session starts.
Very well, yes. I mean, certainly we're dealing with conditions first on that day, if we were to complete our consideration of conditions in an hour and a half, I would still break for lunch and not come back and start on the consideration of site inspections and closing submissions until after lunch. So it will definitely be after lunch.
Yeah, it's just.
I'll try and give some indication over the next couple of weeks. Yeah,
that would be most helpful. Thank you, sir.
Good. Then I think we can wrap up for today. Thank you very much for your participation. We've had a few technical problems, but I think we've got through and understood each other. And I've had some very interesting evidence from you all. So thank you for that. And I'll stop there. Thank you very much. Goodbye.
Thank you, sir.
Bell.